Nomadi simple. Nomadi. Nomadi ধারণা আছে। Now this report is up to 27 to 2025, 26 now.
Mr. Chandran, tell us one thing. What has happened as regards the director of prosecution?
As per the information that Lordship, as on now, as the RR is not ready, Lordship, they have sought some time. It's telephonically they have instructed me, Lordship. But our director of prosecution, he is appearing online also, Lordship.
Where? Mr. Monto, any
My lord, your lordship kindly serial
any
number
update
12.
on the
Hello?
any update on the disposal of the cases
My
in
lord,
the meantime?
latest report has been submitted. That is up to my lord 27 to 2026.
What is that?
That is a. That is up to 27 February.
Hello. Yes, yes, we have it.
Your lordship kindly see serial number 12, my lord. That is the one of the oldest cases, 2003. 2003. Question case number 95 of 2002. Dibrugarh. Case was fixed on 6/1/2026, but no PW flag. Case 6/1/11, but you have some prosecution government.
Now, Mr. Mondo, tell us what is to be done. You see, what is happening out
Your
here.
lordship kindly see
Prosecution is
report
not.
itself is incomplete, my lord. Your lordship kindly see the report, the notice sent, but they did not. But whether notice has been served or not.
No, that is one thing. Now, the question is, can the prosecution at its liberty not produce its evidence? It is their witnesses.
No, normally, my lord, these are all actually that official witness are they are not flouted the order of the court, my lord. Whether, my lord, is going to the proper place or not, my lord, because these are the witness prosecution. Otherwise, without those prosecution witness, my lord, that case cannot be proceeded, my lord. Otherwise, you
So
will
that
get.
you understand what my lord is asking is, prosecution it is not appear. Can it continue like this from 2003? What are the provisions in CRPC?
No, normally, my lord.
And are they at liberty to
Yeah.
continue like this?
No, correct, my lord. But normally, once he is not
CRPC
appearing, then normally one issued against him. Whether in that step has been done or not, my lord.
Are you therefore suggesting that the court is not taking up the case in a more serious manner?
My lord.
Because you see, this is a special bench sitting only for
Monitoring.
monitoring
Monitoring.
MPMLA matters. So therefore, and there is a direction passed by the Supreme Court out there so that it is done on a way, giving more impetus out there.
Yes,
Now, here is the case where we see 2003, a matter is being pending on the ground that the witness is not there. Prosecution witness. Prosecution witness, if it is not there, what is the next consequences to be followed if they don't produce it? Can it be allowed that, okay, they will keep on coming like this? Now you see, page serial number 12.
yes.
You see, the case was fixed on 6/1/2026. PW is not present. Then the case was fixed on 11/2/2026,
PW
meaning
not
hereby it is after more than 1 month.
1 month.
This is how it is being functioning. Next date it is when it is fixed, nobody knows. Because it should have been mentioned what is the next date fixed, because this report is as on 27/2/2026. Now the question is, can the prosecution delay a proceeding?
Certainly not.
What are the provisions out there
Sure, sure.
in the CRPC in that regard?
Informant appears after recent hearings, exam, cross-exam, discern. Further steps have been taken for prosecutions.
Witness. CRPC. Summoning the witness. Summoning the witness. যদি নাহে কি কৰিম? নাহিলে কি কৰিম? আহিলে হোৱাই ইছ্যু কৰিম। 214, 256. The absence of complainant here. কোন নাই আনটো? সমস্ত witness আছে। সমস্ত উপস্থিত আছে। 256 কি নাই? 256 এটা হবে। This is how to complete international complete global news. Excellent. Photo. You need to live. Section. Ile কি করবে? Plus committee will have wide disclosure. Perform variable terms of to the script.
No.
এটা date হল।
What is the present?
তো আছে, টিভি update কৰি থাকে, repeatedly then part two।
If you want to section DNSS, DNSS.
This case is pending before which court?
Session, my lord।
Sessions where?
Session।
Yes, Mr. Bhukon, which court this case is pending?
My lord, here it says written as my lord session case means district and session judge, my lord.
Not before additional district and session judge.
Probably, my lord, because designated, my lord, they have designated the additional district judge, my lord. The case has been designated by the session judge, my lord.
No, that I know, endorsement,
Yes, law,
I know.
my lord.
But are you aware where this case is pending?
No, my lord. In pursuance to the, my lord, last order passed by this honorable court, my lord, we have accordingly communicated the senior superintendent of police
2003।
with these letters, my lord, to.
No results are forthcoming.
My
We're
lord.
only writing, so we did not look into those.
And moreover, my lord, we have done VC video conference along with the SSPs and public prosecutors to do the case, my lord. And also we have last occasions, my lord, your lordship has passed a direction to furnish a report. That this report is with us, my lord.
No, it doesn't seem that there is any urgency shown by the court also.
My lord.
So if the court is not showing any urgency, then we may ask the court to transfer it to some other court.
My lord. Yes.
We ask which court it is. Let us therefore know which court
Just
it is.
I'll check it। আচ্ছা। Yes, my son। Need to flow also।
Now, Mr. Mozumdar, tell us what is to be done if the prosecution is not being able to produce the witness.
First thing।
First of all, my submission is that action should be taken against the witness itself, because notice was served in this case.
Upon
Witness. It doesn't say that notice was
whose duty it is?
served.
Absolutely. Now, if the prosecution has failed to act, so we have this has to be closed. Then proceed to the next one. It cannot go in this manner. Gone are those days by which you keep on allowing time for everything. Now, in view of the recent judgment passed by Justice Pardiwala in that case, it cannot go on like this.
My lord, it is before the additional district and session judge দিব FTC। First take the go to first take। My lord, it is before the additional district and session judge FTC দিব।
Who has prepared this report? Report to Pune. Registry.
Signed by administrative officer, judicial statement of.
Huh?
Was signed by, probably prepared by the, my lord, register administrator.
The reports.
My lord,
What are the
that's why,
original,
my lord, I am.
what are the original report, then we'll not rely
Yeah,
on
when, my lord,
registry and we'll go by the original report that has
Sent to
come
the
from
registry.
the judicial office.
Yeah.
It's a not-
Because your lordship kindly see, neither, my lord, under what section case is in proceeding, no details is there.
You want to know what is the report, actual report from the
My lord.
trial court.
Again, you too. Negosiation, detailed plans for the population.
I'll come to 62. Number 60.
Serial number.
Now, you see, these are 2014 matters.
My lord.
Why there is no date fixed between in 2 months? Isn't it something very serious? Taking into account that
Because
on one hand, the Supreme Court has been asking us to monitor out here so that these matters are disposed of as quickly as possible. Does it make any sense out here?
the earlier order passed by your lordship, my lord, the death judgment was also communicated to them by the, my lord. There is a direction to this commissioner will court.
It appears there's a serious dereliction of duties by the officers also.
All the,
Yes, all, listen,
all these.
during this period, my lord. My lord, all those, my lord, who are very old matters, my lord, specifically, my lord, all details are required to be, my lord. I
We are proposing another thing because it is nowhere happening in this manner. From 2020 onwards, the cases which are pending, we need not put too much on that. But prior to that, those matters which are pending, although the Supreme Court says that 5 years is too long, we give away 6 years.
Please.
And prior to that, whatever those matters are there, they have to deal with one by one, asking the particular judge who is there on video conferencing why the delay. And apart from that, if the prosecution is not in a position to produce the witness, matter has to be closed.
Yes,
It cannot go on like this.
my lord.
This is not thinkable that a prosecution witness, they may have hundreds. First of all, the prosecution should also know how many witnesses are required. Put 100 or 1,000 out there doesn't make the sense.
But quality is.
Now, if they put 100, it is their responsibility. And in view of that judgment which has been passed recently, prosecution needs to produce everybody. Now, if they don't take steps, it is the prosecution who has the control. The court will issue the summons or whatever, warrant or whatever may be to the witness out there to be present. It has to be enforced through the prosecution, through the police. The prosecution has the means to enforce it. And if the prosecution is not giving any importance out there, then it's the prosecution should stop adducing those witnesses and go ahead. The trial has to end.
Yes, no, trial definitely trial is going on because whatever the witness they have already recorded and they can go by that matter. This is if their prosecution fails, my lord, because I have seen in one case 422 witnesses there. Out of that, 174 has been examined. God knows, my lord, other 200, my lord, how it will take, my lord, 5 years, 6 years, maybe 7.
It makes no sense to have
Because I have
400.
seen only one. That is CL number 67, my lord. Your lordship kindly see. Total witnesses, my lord, 270. Out of 120, they have already been examined. Equally.
And Mr. Pukul, what are these witnesses? What type of witnesses are there? Is number 67? Are they formal witnesses? Please come.
67 is NI matter.
Are these formal witnesses?
Lordship, as per my instructions, Lordship, only 3 witnesses remain to be examined. And the matter was fixed on 9/2 and 10/2. However, the witnesses did not turn up, Lordship. But the present position is now the court, there is no presiding officer in the court. So maybe on the next day. So 3 persons remain to be examined as per my instructions, Lordship. Those are the one Kishan Kumar, one sanctioning authority, and there was a subsequent officer who was there. Lordship.
So therefore, if these are formal witnesses,
Lordship.
official witnesses, can't it be done through the evidence on affidavit? And
Like
then to
I'm told,
cross-examination?
Lordship,
Because
2 of
they
them
either
have
put-
retired. 2 of them have retired, so that is creating a problem. One of them is abroad.
Witness, that's it. It is, it shall be taken in the pendency. Which you can give by evidence on it. Maybe that will be subject to cross. Someone. Evident. It's.
Photo sheet. First time already. ঠিক আছে এইটো সেই সেশন কেসটো ডিটেইলসটো উলিয়াই পেলাই আনিছো গোটেই ভাই উলিয়াই আনিছো বহুত আছে সেইটো আহিছে নাই
Mr. Mohanto, if I'm not wrong, there is a provision in the CRPC
pilot
which provides that in respect to formal witnesses. Oh, I think it will be nearby 200 somewhere. 200 or-
CRPC.
The procedure prescribed section 87 onwards will have to be followed.
87 BNS 90 87 CRPC
Initially, initially warrant, then NBW, then
Then-
attachment of property.
নাই নাই
So the only way, if it is these formal witnesses cannot be, which is otherwise permissible under 200, which is similarly provision if we are not going to have it by putting on evidence on affidavit. The only thing, if the sanctioning authority does not turn up, either take it by video conferencing. That's the only way out. Why that is not being resorted to? Why you're not asking? Because you see, a sanctioning authority, who is going to prove the sanction aspect,
Sanction.
he may be a busy person. For him to come over to the court may be difficult for him. Then why you are not resorting to the video conference?
No. Difficulty is lordship, he's retired. He's
Therefore,
he's
he's
retired.
retired, don't disturb him, have a video
no,
conference.
he's abroad again.
Huh?
He's abroad.
outside India
That is creating a problem, lordship.
No, he is abroad very well, or if he doesn't wants to come, that's a
No.
different thing.
Lordship,
Then the next course of action has to be taken.
lordship.
Because if he is abroad, if he is otherwise willing to give the evidence, he can give it by video conference.
Lordship.
Abroad, he can give it. Now, if he doesn't wants to give it, then you can't put him or put put him in gunpoint and ask him to give evidence. No. So the only way is how you have to proceed.
Lordship.
যিকোনো রুলস লব পারে আমি বলবো
Then 15 all the
মই ডিফিউজ কৰিম
Four points, Israel's. His name was Israel's.
Yes, Mr. Mohanto, give us suggestions.
No, my lord, first your lordship kindly, those who are very old case, my lord, that's why my lord, specifically, my lord, each and every, my lord, every report has to be submitted before this honorable court. Otherwise, my lord, here in this case, if suppose been Dibrugarh case, my lord, whether notice you is served or not, my lord, simply says that my witness not appeared, witness not appeared. Suppose witness might staying in Gauhati, my lord, the notice was sent to Dibrugarh. So how it can be, my lord? So what is the actual position that is not reflected in the
No, we therefore ask the district judge,
yes,
district and session judge.
no.
Now the question is not in his judicial capacity, but in his administrative capacity,
My lord.
to give us information about this stuff,
For that, my lord,
as
what
to
I,
why it has not happened.
my lord, exactly.
Now, the question is, that is one thing. He may come up with this, that the prosecution is not producing the witnesses. Now, what is the next thing to be done if the prosecution fails to produce the witness? Then the matter has to be
yeah, my
closed.
court has to proceed whatever the available.
Court has to proceed.
Yes.
If the prosecution fails to produce, then it has to
Yes.
proceed. And what is the sum and substance of the evidence which is
Because
to be given?
Court cannot
The
wait for
court
the.
cannot keep on waiting for that. And if the prosecution, nowadays you have a director of prosecution who is looking into all these things.
My lord.
So they are now in a more professional manner. Now, therefore, the older the case gets, the witness will be more scared. And at the end of the day, nothing is going to come up. Isn't it? Because no witness would like to say anything. Why after 10 years, 50 years? This is the case of 2003. Must have happened much. The incident must have happened in 2001 to maybe much earlier in the 90s. And thereupon charge sheet must have been submitted later on, then committed or whatever maybe. So now it is in 2003. We are 23 years old. So therefore, this person concerned maybe these people maybe 25 years old. They must have forgotten. Nobody wants to give evidence. Witnesses must have died, and the prosecution is also not aware as to whether the witness is alive or dead.
Generally, what happens, my lord, if it is the prosecution witness is not sworn out for a long periods, my lord, then prosecution witness may be closed, and next step is, my lord, the accused may be, my lord, the giving a sufficient, my lord, the 313 procedure, my lord. Thereafter, the defense witness and the matter may be closed, my lord. That is the procedure.
That we understand. After a long time. What do you mean by a long time? Is it a long time to say that it is 10 years?
No, my lord, in 2003.
In this 2003 matter must have started around 15 years back.
My lord.
Isn't it?
That is report
2003, if it is a case, when it came before the court, they've gone for the purpose of copy initially, then charge framing. After the charge must have been framed in 2005 or 7 or 10. Let us take it on 10. Still 16 years. So therefore, prosecution witnesses must have forgotten everything. You have to give up your fight.
My lord, I have checked it up, my lord, the Dibrugarh case. Last 5 days, my lord, 3 days no PP and 2 days no court. That is the position in last 3 days. 5 days. I have checked it, my lord.
Now, one issue is going on, my lord, regarding the, my lord, PPs. In the most of the court, my lord, PPs are not there because of, my lord, the now is transition periods. The new PP has come upon, my lord, on 2nd of this month, my lord, we have, they have joined, my lord. And now they go for a judicial academy for 6 months training. So the existing PPs, most of them have been resigned due to, my lord, frustration because they are not regularized. So as because, my lord, in most of the courts, my lord, PPs are not available. We are facing this problem for last 3-4 months, my lord.
So when are you going to think coming up with the PPs?
My lord, on 2nd of this month, my lord, they have joined, and we have sent them for a judicial academy for another 6 months, my lord. That's why these 6 months, my lord.
For next 6 months we have.
My lord, yes, we have facing, my lord, lots of problem, my lord. Because nobody has come for, my lord.
In the state for these bails and all day-to-day target the trial, we can understand for that.
But these are the problems we are facing, my lord, because new PP, well, temporarily no has come, my lord, for 2-3 months, my lord. So if we, my lord, engage some PP for 2-3 months, they will not come, my lord. So these are the problem we are facing, my lord. So every day we have received complaint from the district judges and, my lord, the lower judiciaries, my lord, PP is not there, PP is not there.
So that means for next 6 months
So we thought, my lord, 2 months, my lord, for 2 months, public prosecutor, my lord, they go for training. The other PPs, those are, my lord, the free. We attach my lord, their respective districts, my lord. So we are planning like that, my lord, because courts should not be vacant, my lord. সেইটো প্ৰব্লেম হৈ আছে পুৰণা পিপি খিনি ৰিজাইন দিছে নাহে কিবা তেনেকে চলি আছে আকৌ
So the PP issue, otherwise the challenge to the PP
মাইলত
cases are also there.
মাইলত
And you, out of 297 posts, you have only filled up 241.
239
Two must have left again. So therefore, the remaining another, these people have also not been filled up on the ground that you have not got good people. And I think there is only one case we have,
No,
wherein four
my lord-
PPs have challenged it. Existing PPs have challenged.
And moreover, my lord, the existing PP, most of they have given a resignations. And the Honorable Chief Minister have assured them to, they have been continued again for last 4 years, 5 years. But my lord, they are showing less interest and because new PPs as regular cadres has come, my lord, they are not visiting the courts, my lord. They are showing less interest as before the appearing in the courts, my lord.
Let me take some of it.
So if that is the situation, I think we should adjourn this matter for next 6 months.
My God, otherwise, was exercising.
But wouldn't that be a failure of the entire criminal
Justice system.
criminal courts in the state of Assam?
My lord.
System is
System is-
for want of people.
I think we should hear the Advocate General on this aspect.
My lord.
Because this has the effect of what you are submitting has the effect of entirely the falling of the system.
My lord, yes.
Something we.
So if you are not in a position, you want to, because these people are, you are want to sending for Judicial Academy for training, that may happen later on. But you
Or
have
best
to also
wise.
take care of the situation which is now going to happen. If you
That's why
don't
my lord,
have PPs or the PPs who were there, they are not interested, having not been chosen or not being selected. They are not interested. And the others, you are now putting them out there, so there is no, the total failure of the machinery.
Defend the prosecute the.
that's why, my lord, we have discussed with the Judicial Academy too. We have sending batch wise, my lord. Not at a
batch,
time,
you
all
can-
the,
no,
my lord.
sending batch, you can have it. Is another thing. You can very well have or send them there whenever it is. But you have to send it in such a manner that the entire machinery does not fall. We do one
And
thing.
one more thing, my lord, the existing PPs are, they are not controlled by me because, my lord, theirs comes under the, my lord, LR, my lord, Judicial Department. So Judicial Department may control, my lord, these existing PPs, my lord. There comes under the Judicial Department. These new PP just
Judicial
comes under.
Department, if it is so, then Mr. Mozumdar is there in the status of an additional Advocate General. He'll be representing them.
No.
We don't require that for that purpose. But the fact that as of now, there is a failure of the total
My
system.
lord, yes.
So if that be so, then I think either you cannot think that, okay, we are going to send them for 6 months and the entire criminal machinery will fall. This I don't think it can be allowed.
Yes.
When will be the Advocate General available?
Advocate
busy
General
these
is
days.
I'll suggest.
After-
Lordship will grant, I have understood the problem. I was not knowing, my learned friend is saying. Let Lordship will grant us around 15 days time. In the meantime, LR, learned Advocate General, all should sit together and take a decision because this stopgap, this period of 6 months during which these new appointees will be trained, something has to be done. This way it cannot go on.
No, it cannot happen like that.
No,
See, you are not, I don't think you are appointing anybody who is a fresh graduate. No.
My lord,
You are
yes.
seeing it. I think these people have been appointed after having some experience.
My lord, yes.
practical.
I think this is a complete failure of the it's a failure of the criminal courts is a part of the constitutional courts.
My lord.
So it is a failure of the constitutional machinery. 356.
356. Constitution. Constitution.
356 coming.
It is because
It is a
this
failure of the constitutional
transitional period,
machinery.
this transitional period of 6 months, something has to be done. We have
They have to be done.
We'll discuss, my lord, because
you have
that's why
taken
we
it a very
In
serious
fact,
thing.
this ought to have been in your mind while you are shifting to the new system of recruiting PPs and all.
Your
Because
Lordship,
you know that these
Lordship.
PPs will have to be trained. They will have to be sent to the judicial academy. So this plan
Immediately after the
would have been
proctor.
on the day of its advertisement. What will be the mechanism during this transitional period?
Yes.
Now, what from your submission, what you could understand is that till the new PPs comes, almost all the criminal courts
Functioning will be
functionings are
slowed
stopped.
down.
Is it permissible?
This is
No,
this
my
can be
lord.
permitted.
That's why, my lord, we are thinking, my lord. There are 239 PPs.
Barring
that-
those cases where you have engaged special public prosecutor.
Yes.
My lord, again, one problem arises, my lord. The special public prosecutor was engaged, my lord, in particular cases.
That's why.
That's good.
I'm
Because
saying
nobody
this
is
except
my lord,
those cases.
Nowadays, my lord, there is very difficult to get the special
Not the
people in
full-
one cases, my lord. So we are searching many, we have given many opportunities to the new lawyers also, my lord. They come, they are not showing interest, my lord. To come before only one cases, they are appearing in.
Because they know that here for some time being, already there is a cadre of public prosecutors, additional public prosecutors.
So that's why, my lord, we are thinking, out of 239, 40, my lord, we have divided, my lord. The first batch, my lord, 40 has gone. In meantime, my lord, the remains where we have attached the respective districts, my lord. To run the courts, my lord.
Administrative side, you have to look
My
into
lord.
distributing where is recruiting required not. But as on that,
Something,
it's difficult proposition.
that's what I'm
So
saying. Well, Lordship will grant us.
That's why we thought that we'll call advocate general.
Yes. Or your
Because
Lordship,
otherwise it's a failure.
my lord. And my suggestion will be subject to what your Lordship decide, madam. That Lordship will kindly observe in the order itself that the problems, the practical difficulties faced by the courts because of this transitional period, as expressed by the Director Prosecution, my lord, that your Lordship will observe, and the Lordship will grant us 10 to 15 days time.
I don't know about my brother. I don't have any kind words to put it. When the transition period have not been taken into consideration
True,
by
man.
the state government prior to doing it.
True. I accept. It's our duty. We should have,
Right, the
we
state
should have
government
visualized it.
taken the example of the central government when how the central government brought in the 3 laws, given opportunities to everybody going on. It has been brought to the notice of everybody that these are the laws which are coming.
We'll come up,
Think
we'll,
something.
we'll come up with some solution immediately so that this transitional period also, prosecution, criminal cases do not go on,
Not only that,
Madam.
while bringing those laws, even post effect of these laws, they did much more for this transition and knowing these lawyers, training them up.
No, therefore we cannot go ahead with this taking into account. No. Heard Mr. T.J. Mohanto, the learned senior counsel, appearing on behalf of the Gauhati High Court.
May I pray, my lord? One more thing, my lord, point to be noted before your lordship. Here, subject to your lordship corrections, in Ashwani Kumar Upadhyay, my lord, here it has been written, my lord, the disposal of criminal cases against, my lord, MP MLAs, my lord. It shows, my lord, against. But here we have found, my lord, so many cases are not against MP MLA. MP MLAs are filing complaint against the general people's, my lord. So that should be curtailed from our list, my lord.
Which are the cases?
My lord.
Which are the cases?
Cases, my lord, we have found.
Maybe again, in some paragraph it's specific that involving MP. Not only against. So far I recall, you will have to go to the judgment. It's involving legislators,
It is
present and past.
That is sitting and former.
Former.
It is there, my lord. But against what is
I
there.
don't see the directions which have been passed.
I have marked my lord, pencil marked it.
यहाँ में अनम्यूट हो गया हम लोग। कुछ सिस्टम में तो प्रॉब्लम है, आ रहा है। पहले आ रहा था यहाँ में एक कंप्यूटर से आ रहा था, कुछ इसमें रीजन करो बोल के।
low network bandwidth.
निकाल के फिर रीजन कर दो, पहले एग्जिट कर दो।
Para 18 and 20 of the page 20.
কোনটো আছনি?
If not, to be against it. Even if it is involving, against even if it is even if the word is involved, it is against.
The involved
Para 20.
তাতে কি ইনভলভ করতে আছে?
Correct na?
No.
ইনভলভ হলো এগেইনস্ট
Against it.
ইনভলভ হলো এগেইনস্ট
Para 22 days. Para 20.
Because it's para 15 also.
No, that's not.
If we have involved in the prosecution, we also say could this be someone prosecution against NPN actually.
সেইটো কৈছো, সেইটো বস্তু 15 পেৰাটো চাব লাগে।
Is no doubt in our mind. Even the political representative, MP or MLA, involved in the prosecution. He's involved in the prosecution in the sense that he's the accused.
He's the involved in the prosecution.
But the word involved.
The word involved being involved. Your lordship can see page 21 of the paper book.
Well, the word involved in
Paragraph 15.
Paragraph 20.
well, the word
In my judgment 15.
word involved is mentioned in paragraph 15. It says, we have no doubt in our mind that even the political representative, be it MP or an MLA, involved in the prosecution, meaning thereby that he is accused in the case.
No, my lord. Your lordship can see page
Paragraph 15.
18, 15, I'm sorry, 15.
In fact, there are no two views about the compelling need to dispose of the cases expediently.
Yes.
There is no doubt in our mind that even political representatives involved in prosecution.
Yes. If your lordship reads this along with paragraph 1, it's yes. So the whole
Facebook
unnecessary. Expeditious disposal of criminals against elected governments. The whole case is taken up. Para 1? No. এই সুমোটো যেতিয়া লৈছে লোৱাটোৱে হৈছে যে
Basically.
Intention to tattoo.
Intention to
Itu lain tu balik ke solution. Further request the learned secrecy of the all the report is the produce all the pending criminal cases involving sitting and combined with this.
It is in that. It is in that. In the sense that it is, if it is against them.
Pending but them what is it?
The other cases should be separate. Can't come here.
So therefore, we can segregate those.
Yes, yes.
Yeah,
Hello, this case,
22.1.
I'm just submitting, this case was never, man,
To 21.
man. Yes,
This is specific.
specific.
So
To-
this bench is for the death cases. only.
Yes,
Only against.
not to help the MPs and MLAs in the cases where they have instituted.
They fight
Yes.
against. They
So-
should be equally placed like other citizens.
Yeah.
We are
The what
trying to get their
pending
cases.
criminal cases involved.
Involvement in the context of
But accused.
Being accused.
being accused.
Otherwise,
That
this
is the-
case was never taken up to help the MPs and MLAs where they have lost the prosecution. So those
Then
cases may be,
most of these
because if the
down
number
and
comes
all
down,
will go.
or if the number comes down,
All complaint, defamation complaints.
no, filed by them.
Of course, most of who are defamed generally.
My lord, they had a complaint in my lord.
Ah.
Supreme Court is complained.
They will take care of their cases. If they have instituted, they will take care of this
That's why-
disposal. Supreme Court was not on this.
So we therefore ask this to be segregated one.
Man.
And second aspect is regarding
Age-wise,
Pendants,
focus.
pendants
Yes,
and
right.
and
Up
pendency,
to
man. Lots will
20,
separate
20.
the recent cases.
2016.
2016.
There are some cases of 2025 also. Those can be separated. my lord.
So
Because
therefore, we
lot of
say
time need not be
to
wasted.
bring us on an update on up till 2016.
No.
So 10 years is okay. For
Right.
the time being, we'll look into it later
Yes.
on. But first is this. And the third aspect is we ask the Advocate General as
Regarding
regards the
PP,
resolution of
regarding
this aspect.
PP.
So when? How much time would it require for you to prepare this?
Yes. Specific.
Segregate those cases which are against. Only those. And those cases where that to up till first to segregate all cases which are where the prosecution is the MPMLA.
The MPMLAs are accused.
Yes.
So those MPMLA where they are the accused, only those cases we are going to take it up.
Then.
Second is we have it till 2016 up to date list, age wise. Till 2016 a separate list and another list. So this is it. And third, we ask the Advocate General how does he resolve it? When can we have it? We are otherwise sitting on the yard.
We'll take an early date because we just need the date so that we can pass
Right.
and have an view of Advocate General, then we'll decide what we'll proceed.
When will the Advocate General be there?
After 9.
We can have it on 13th, my lord, Friday. Oh, ठीक है sir.
That will be on 16.
16th, we can have it on 16th, my lord.
10th,
Yes, my lord, he is available 10, 11, 12.
Okay, 10. Okay, we will pass the order.
This is a pending.
Order 6 may be, if we examine the order 6, then we can come to know as to what are the reasons.
Nityam upon.
Then
No,
we can go
no,
the next date.
we,
Let us have the list.
we are going to do on the next
Yes,
date.
yes.
Now, what we are trying to do is we are segregating those cases where only the MP MLAs are the accused. One, we are also bringing another list whereby we are taking, we are not going putting our foot too much on those matters which are pending for 10 years. So any matters which are after 2017 or after, that is okay. But till 2016, all matters on a separate list is to be provided. And once it is, and we are asking the Advocate General to be appearing on for the purpose of how to take into account this transitional period. This is the three things which we propose. And on the next date, we can ask them these 10 years, all these matters which are there, asking them the order sheet as to why the matters are pending. And then we ask them, more particularly matters like the 2003 matter, there has to be a day to day. And that we will first let us now take it out. But asking them the total order sheet is also, it would be difficult, taking into account that somebody has to give a summary.
Somebody can issue the order. We will think that somebody can give a note on file of disseminate. More than 10.
But
usually your will be able to pass it purely for the.
my lord, the last occasion, my lord, there is a clear direction of this honorable court to submit a my lord report. The report should be kept record.
What is that report?
My lord, the last occasion witnesses. What happened? Direction is
Now there
He-
is no,
he is not there.
there will be no full result.
No,
for
my lord,
this year with
there
that.
is a judicial
Because
order,
like
my
the
lord.
death case one Dibrugarh, no PP, so we'll go back.
My lord, yes. Why I am submitting my lord? Because there is a judicial order to direction to
That's
submit
correct.
before.
You produce it on next
Next
date.
day.
What on?
Somebody wants to mention?
With the consent of other side, I beg to mention item number 13. Right, so 1 week time I have to file our definitive reply, sir.
Item number 13.
13, ma'am. 113 of the daily list, sir. Right, 1 week time to file definitive reply, sir. To the definitive opposition file very private respondents.
The learned counsel appearing on behalf of the petitioner submits that he would like to file that the petitioner like to file an affidavit in reply. Accordingly, list this matter again on 9th of April 2026. Affidavit in reply be filed on or before 6th of April 2026.
Obliged.
Your Honor, may permit me to mention item number 30. This is the patent matter where I was to file my amended counter claims. So I'm in the process of filing it. It'll be done by the end of this day. I've served the advance copies in my learned friend.
You have filed or not?
I'm in the process of filing.
I fixed the date.
It'll be filed today.
No, is the date over or not?
It's not
On or
over.
before today. It was supposed to be filed on or before today.
On or before today?
Today.
You have filed it.
It's in the process of being filed.
So it is going to be filed today.
Yes.
If it is not filed today, then
Consequences will
your
flow.
amended written statement will go.
Yes, Your Honor mentioned it on the last day. Your Honor did mention that on the last day.
Mr. E. Das appearing on behalf of the respondent number 2 and 4.
2, 3, and 4.
2, 3, and 4 submits that that in pursuance to the directions passed by this court, the amended counterclaims preferred by the respondent numbers 2, 3, and 4 are in the process of being filed today. Why haven't you filed it?
They have to come from Bombay. It got stuck actually because of Holi. So I've received it last night. So I'm filing it right now. It's fully
No,
executed.
One thing, you file it. You file it because then I'll have to fix a date for filing of the written
Very,
statement.
very,
It is not like a repetition like this. No, I don't order no.
very well.
Bring it. You want to bring that document, we can permit you to
Yes.
bring that document
Obliged.
before the matter reaches.
Obliged.
Otherwise, we'll construe that it is not filed.
Please, Lordship, I beg to mention item number 2 of the daily list.
Item number?
2, my lord.
Yes, what do you want?
Lordship, for adjournment only for the day, Lordship.
Why?
Lordship, I'm led by the learned advocate general. Lordship, it's little difficult for him to appear today. Lordship, can be fixed next week, any day, Lordship, on Tuesday.
What is the matter about?
Lordship, matter is about the elephant joy mala. It's about the elephant joy mala, owned by the state of Assam, who has been held captive in a temple in Tamil Nadu, Lordship, beyond the prescribed period. But therefore, we find this.
Though we like this is leading the state of Tamil Nadu and Assam, but my concern is that the elephant is still suffering. He is under legal captive since 8 years, Lordship, under the Tamil Nadu. He often have been referred to come back to Assam, Lordship, the way back, one became back, Lordship. But still it is under the legal captivity of Tamil Nadu. And the elephant was treated under the violation of the wildlife protection.
Lordship, I appear for the state of Tamil Nadu, respondent number 226, Your Lordship. And this is wholly not correct, Your Lordship. The elephant is in good health. We have been filing periodic medical reports of the elephant. Even the last one till the date 23rd of December 2025. I have filed it on the 27th of this month, February, 27th of February. It is not on record, but her health is very good. She's been looked after. There is no any reason, but otherwise, depending on the prayer of the maybe if
Who are you for the elephant?
Lordship, I for the organization. When I highlighted the issues, Lordship, then the states came to know on the organization.
they appear for PETA, Your Lordship. PETA. The dispute is basically between the state of Assam and the Tamil Nadu government. Also.
You have not filed a writ petition. You are an intervener.
First, there is an HPC, Lordship, which wants to try to Supreme Court Lordship on the procedure of Lordship. That HPC, all these issues, Lordship, where the concern, the agents are concerned, Lordship. All the disputes are always Lordship resolved by the HPC, Lordship. So one of the humble prayer is that Lordship, like really got the Lordship, the ready Lordship.
We'll look into the reports which they have submitted. You are concerned about the well-being of the animal. The reports which the Tamil Nadu government has submitted. Does it seem from the reports that the elephant is in distress?
So they are on every occasion they disobey. They don't file anything on record.
Have you filed something?
They have not brought. I have been bringing regular.
He has submitted on the 13th of February.
No, 27th of February. The medical reports, 3 quarterly medical reports.
Have you looked into that? You are not aware. PETA cannot have anything else. See, the state of Assam question would be different. Some elephants have gone out here without taking into consideration the various laws laid down out there. That is another thing. But PETA thing would be as regards the well-being of the animal. Now, if the well-being of the animal is otherwise having no problems out there, as per the report which is being submitted, and you have nothing to contrary. So your thing is duly taken care of.
My confidence.
Or is it that it should be only in the forest in Assam?
Previously also, Lordship, they have submitted similar reports, Lordship, of veterinary research project. But those reports are always contrary with the investigation that we have conducted.
Their investigation, Lordship, there is nothing. That's only surmise and conjectures, Your Lordship.
Goes inside the temple, Lordship, they are being beaten up, Lordship. The cameras are.
That representative of temple is here, Your Lordship.
Lordship, I'm for respondent 11 for the temple, Lordship.
Respondent
11 for
What
the
is that?
temple, yes. Respondent
for
11,
the temple.
yes. Lordship, I think temple is a better place for the 11.
Okay, we do one thing. We have this matter on another day. In the meantime, if you have any objection against the report, put it on record.
No objection, Lordship, I'll bring on the latest update. If I have anything, Lordship, I'll bring it on the record.
Let them bring it on record, because otherwise it is
Any
only.
latest development, Lordship? Yeah.
No, are you indicating that you are going to make verbal submissions on the report?
Lordship, against the report, Lordship, I cannot, I'm not in a position to say, Lordship, because I was never allowed to go inside the temple, Lordship.
Oh.
Whenever I have to go.
It's a registered body of the Government of Tamil Nadu Forest Department, Your Lordship.
I've been joking.
The medical reports are prepared by hold on a minute. The district level captive welfare and welfare committee, Your Lordship. It's a government formed committee which quarterly evaluates the health of the elephant. And the last quarterly report was of 23rd of December last year, 2025. Up to that, and through previously quarterly report of medical reports, I have brought on record the affidavit.
It's okay. Miss R.P. People, appearing on behalf of the petitioners, admits that some time is required, taking into account that in the instant writ petition, the Advocate General will be appearing on behalf of the state of Assam. Taking into account the above, lists this matter on 12th of March 2026.
When?
12th of March.
Lordship, can it be on 13.11, Your Lordship, 12?
You are?
I'm going to stay of Tamil Nadu, Your Lordship.
You come from Tamil Nadu.
No, I'm here.
Then?
No. We have some prior commitment, Your Lordship. Can it be on 11 or 13, Your Lordship?
No. Well, I give dates as by my convenience, not the convenience of the council. But
May I please, Lordship? So with the consent from the other side, I beg to mention item 1. Sir.
Huh?
With the consent from the other side, I beg to mention item 1. What the goes?
Item 1,
Yes, Lordship.
2015 matter. How can I adjourn it?
Yes, Lordship.
You want to withdraw?
Lordship, as per the order dated 7/6/24, Lordship has directed the counsel for the petitioner to bring on record the affair and the order for the learned magistrate, Lordship. Thereafter, the council could not contact the petitioner, Lordship.
Then we dismiss it. No adjourn. Item 1.
My lord, the item.
Appears on behalf of the petitioner on call.
I agree with the respondent for you.
The so and so appears on behalf of the respondent number
4.
4. The petitioner herein have assailed the election of the respondent number 4 on the ground of improper acceptance of the nomination of the respondent number 4, isn't it?
Yes.
It is the opinion of this court that taking into account the provisions of Article 243(o) of the Constitution of India, read with Section 129 of the Assam Panchayat Act 1994 and Rule 4745Z of the Assam Panchayat Constitution Rules 1995, whereby the provisions of the Representation of People's Act 1951 is duly applicable, comma, the said ground on which the instant writ petition is being filed being a ground available under section 100 of the Act of 1951, 101D of the Act of 1951, comma, the writ petition under Article 2 to 6 of the Constitution is not maintainable. Accordingly, the writ petition stands dismissed.
Yeah, please, Your Lordship. On the last occasion, Your Lordship asked us to see whether there is any amicable settlement, there is any scope of a settlement. Under the management and the workman at the sitting, out of the three employees, one was sleeping.
One is working,
He's
as regards the two,
other two,
I've asked them to file an affidavit.
my lord, we couldn't file it. It's in the process of filing, my lord. Only one has accepted the terms of settlement.
The other one,
The other one, he does not accept. You can see.
There are three workmen, my lord.
no, one has joined.
Yeah, one has joined,
So the remaining are two.
remaining two.
So of the two, what has happened?
One expired, my lord.
One
So
expired, and
whether the legal representatives have accepted it?
they have accepted.
And the third one, my lord, he not agreed for the settlement. Settlement is the proposal of the management, regarding calculation, he has objection.
Is not?
He is not agreeable because the rate of wages considered by the management was not acceptable to him. Because at that time, there was a minimum wage. At that time, there was a minimum wage, and but the management doesn't want to settle the matter on the basis of the minimum wages.
So he is not being given the minimum wage.
My lord?
He's not being given the minimum wage.
No.
Huh?
No, not.
As per you, how much it should be?
Actually, at that time, their very rate of wages is very low. They're 45, 50 rupees per day. But minimum wage is much more.
How much?
Minimum wage is double, more than 100 rupees. my lord.
Okay, so 1 year, how much it would be?
It will be more than 50,000 rupees, my lord. Now, they are calculated at rupees 30,000 only. But according to him, as per on the basis of the minimum wage calculated, it is much more.
So you want 50,000?
No, yes,
We'll have to take instruction now. After some time, if you lordship.
actually that should have been calculated on the basis of the minimum wages, my lord.
It's okay. Mr. Das, are you agreeable for 50,000? Are you agreeable for 50,000?
As per calculation, it will be more than 50,000, my lord.
How much?
Exact amount I cannot say at this moment, my lord.
So that person does not want to compromise.
Yes, my lord.
That is the final thing.
Yes, on the basis of the minimum wage, if calculated, he is agreeable.
So how much it would be?
It is, right now I cannot say, my lord.
Find it out. We have it on some other day.
Yes,
Come up with that.
yes, my lord.
And in fact, I was thinking this amount should have been much higher. This person has agreed to 28 and 30,000. This is too low, Mr.
Too
Prasad.
low, my lord. Yes. It's too low.
Don't agree below a lakh. Don't agree below a lakh. My question is. I never thought that.
Yes, my lord.
I thought something more than that would have been there.
I also never thought that.
Why this person have gone for that? Let them argue.
It should,
Finally,
it should be calculated on the basis of the minimum wages, my lord.
it is seen. Pursuant to the order passed by this court on 3/2/2026, a joint affidavit has been filed
Today.
by the petitioner with the son of, with whom? This agreement is signed with whom?
All of this agreement is signed between the legal representative of respondent number 2, Shashi Mohan Roy's son and wife. That respondent number 5, or 4, Pavitra Kumar Roy, the management, and Jitendra Roy, he is the general secretary of the trade union.
A joint affidavit has been filed on behalf of the respondent number 2, 4, and 5, whereby it appears that there is an amicable settlement by and between the petitioner as well with the respondent number 2, 4, and 5. Mr. Das, the learned counsel appearing on behalf of the respondent numbers 3, 4, and 5,
Yes.
submitted that there is an ongoing discussion as regards the respondent number, as to whether the respondent number 3 would accept, inasmuch as the respondent number 3's demand is that the 1 year's the one-year wages has to be computed as per the then existing minimum wages
Yes.
declared by the government of Assam under the Minimum Wages Act 1948.
Yes.
Full stop. Mr. Prasad, appearing on behalf of the petitioner, submits that he would obtain instruction in that regard. Taking into account the above, when? 13th March?
Yes.
Or should we have it on 30?
Yes, my lord.
List this matter again on 31st of March 2026. In the meantime, if there is a settlement by and between the petitioner and the respondent number 3, the same be brought on record in the manner stated in the order dated 3/2/2026. The registry shall also bring on record the joint affidavit filed on behalf of the petitioner, the respondent number 2, 4, and 5. List accordingly.
Obliged.
That my case is simple manner. It is manner. The petitioner is a electricity consumer manner having sanction load of 635 kilowatt manner under the HT category. Category of
Mr. Saikia, I know your case. Your case is very thin. That it couldn't have been for 12 months. It should have been for a period which could have been ascertained.
Yes.
And therefore here they say that on 22/7/2015, there was an inspection being carried out and it was found to be good. However, on 8/5/2016, this inspection was carried out.
My lord, that earlier inspection was on 22nd of August 2017.
17 and on 8/5.
24th of May 2018.
24. Do you mean the date 20?
4th of May 2018.
The date of inspection earlier was 22/8/2017
17,
and 24th of May
2018.
2018. So there. So therefore, the period which is to be calculated as per the n factor
Yes.
would be taken on the basis. And on that day also I say that it has to be for the period where in the meter it was shown that there was beyond the
Contracted demand.
contract demand. So in the meter, it is being shown that for 3 months there was so.
4 months, ma'am.
4 months.
My lord, 4 months have mentioned by the respondent authority while preparing the assessment bill after order passed by the appellate authority. But for the month of December, that overdwell penalty, how imposed, it is wrong, my lord, because
Huh?
my lord, that was wrong, my lord. For
Why?
the- My lord, kindly see the bill, my lord, that is in WPC number 646.
Where?
At page 82, my lord.
Page?
Annexes 70.
80?
My lord, 82.
Ah,
Here, my lord, maximum demand recorded as 384 kVA. But at that time, my off-seasonal contract demand was 403 kVA. It's below the 403, my lord. That's why it should not be penalized for hardware penalty, my lord.
where?
My lord, that is, I have annexed in WPC number 81. Agreement is there, my lord. Agreement is,
Now, this is for the period from 2017.
yes, yes, that's it.
1/12/2017 to 31/12/2017.
Yes, your lordship.
So,
My lord,
so it has to be from the this. Let us see the month for January,
yes, your lordship.
which is the bill for January.
My lord, I have not annexed the bill for January, my lord. That was not mentioned in the bill prepared, which is at page 79 of this petition, my lord, that is 646. Assessment bill. Here mentioned about the bill period August, October, December, and February, my lord. February 2018.
No. Tell me one thing, Mr. Chaudhary. Tell me one thing. Kindly come to page 80. Here, if you see, this is for the period 1/8/2017 to 31/8/2017. Okay. Now here the MDA KVA is 496. This is higher
This is higher.
than 422. Yours is 403.
No, my lord. At that period, that is seasonal. Seasonal was 485.
Oh, so then also it was high,
Yes, my lord, marginally high.
485.
Which is
So
also permissible as it's up to 105%, my lord.
105% also would it come in
Permissible
it?
as by agreement, my lord.
Okay. So anyways, so this is it. So here there is some overdrawal charges has been taken.
Yes, my lord.
So my question is, if this is the overdrawal charges you have taken here, then on 22/8/2017 you found there is no problem.
In the meter, as far as the unauthorized extension was concerned, my lords, the issue, my lords, there's been an issue. They have been seeking since 2011 an extension of the load, my lords. So the amount was ascertained. He was told, my lord, the petitioner was informed that there are certain provisions under the electricity supply code which they need to fulfill. This is under clause 5.8.9. Agreement has to be executed, payments have to be made. They did not do it, my lords. Why this is important is because, my lords, the agreement in question
which also shows the sanction load as well as the contract demand for the season as well as the
Where is that?
off-season period. Now, the agreement is at page, it starts at page 38,
In WPC number 81.
the item 25.
I'm looking into 646.
The agreement paragraph is-
Agreement have not annexed in this petition. At least 30.
30?
8.
38 months.
Yes.
Here
Here-
below,
Sanction is 635.
635
six-
kilowatt, 747 kVA,
Connected load is 747.
747 kVA, 635 kilowatt. Contract demand 485. It's 65 to
65 to
0.05%.
105% of the connected load.
my lord,
No. What do you mean by this? 65 to 105% of the connected load. Connected load is 747. What does it mean? Mr. Chaudhary?
then understand my lord, the contract demand may be within 65% to 105% of the sanction load connected to it.
No. Kindly come to there, down below.
Yes.
For category T, coffee, rubber,
Yes,
that is yours.
Yes.
Your T category rubber,
Yes,
no?
sir.
Seasonal contract demand,
Yes,
485.
485.
March to Iman, 65% of the connected. Here, 105% doesn't come. It
hello?
won't come because this is specifically given for you.
yes,
For T category, there is for 65% of the connected load. Then off-season 403 kVA December to February,
yes, sir.
83% of the seasonal contract demand.
Seasonal connected, contracted demand.
Contract demand. So here the seasonal contract demand, you have 83%.
Yes, sir.
So this is the agreement.
This is the agreement. In continuance of.
So then you see the next page,
Yes, sir.
connected load 746, 634. Then seasonal 4 April to 65% of the connected load. Because the connected load and the sanction load happens to be the same.
This-
Sanction load and connected load, same.
So therefore, they are putting at 65% of the connected load. And off-season is 62% of the connected load.
That is 300 kVA.
The page 39, my lords, is the,
So this is again different.
yes,
Yeah,
this
different, my lord.
page
It was-
38 is an addendum to the earlier agreement.
Lord, it was.
The page 38 is this. This is done on 2017.
31st August 2017.
Like page 39 was executed on
This was the earlier one.
earlier, 2010.
So this is the addendum.
Yes.
Yes.
So at that point of time, this was holding it. This happened on 28/8/2017.
Yes, my lord.
Now, this is very interesting, taking into account, this happened on 28/8/2017, isn't it? The date or 17/7, 17/7/2017. And the inspection was carried out on 22/8/2017.
Yes, my lord.
My lords.
So they, just before the inspection was carried out, there was this increase. And thereafter, inspection was carried out. And then it was found to be okay. Now, when it is okay, thereafter, during that period, now as we can see out here, the bills,
Yes, my lord.
we are only concerned out here pertaining to, you see the appellate considering the above, the assessment of so and so on the quantum of so and so found connected for a period at the double the tariff prevailing at the respective, if any advance payment or trial has been recovered, so and so. So it cannot be 12 months. It has to be after 22/8
After 22/8,
and
going up
taking into account till the date on which the inspection was carried out, and also taking into account as in the meter wherein overbilling was shown.
overdraw, yes.
Overdraw. That's all.
On
Thereafter, you have to work out. I'm only modifying the appellate order, nothing more than that.
Yes, Your Lord.
that assessment, perhaps reassessment would have to be done, my lord, in this
Ah,
case, perhaps.
so therefore, what is here, what has happened? It's page 133. It says the assessment on the unauthorized use of electricity by the appellant may be made as per the section so and so of the Indian Electricity Act on the quantum of the excess 422.64 kW
My lord.
load found connected for a period of 12 months at double the tariff prevailing at that respective period. So it was made double the period for 12 months. I don't touch any other thing except I say that you cannot do it for 12 months. You have to do it after 22/8 because as on 22/8 it was okay. Thereafter, if there is a case of overbilling, then only you can do it and then make the reassessment bill.
My lord, in that case, I want to say one thing. my
You
lord.
don't say anything more. I've given
My
2
lord,
minutes.
so only on that issue, my lord. Only on that issue. That is, my lord, the overdraw was, my lord, on the contracted demand, not the sanction, my lord. Sanction was 635 kilowatt, my lord. That is 747 kVA. And maximum load that petitioner given in the month of October, that is 502 only, my lord. That is beyond contracted demand. Contracted demand was at that time, my lord, 485, my lord. And another thing is that, my lord, the quantity. Here, the appellate authority considered it as 422.64 kilowatt, my lord. Considering total connected load as 1057 of .64 kilowatt, my lord, which is not reflected in the inspection report. Inspection report reflects only 804 kilowatt total connected load, my lord. If it show, my lord, that as per physical verification, it should be only 169 kVA, my lord. Kilowatt, sorry. 169 kilowatt, my lord.
Why?
That is, my lord, that 254 kilowatts, 253.64
No,
kilowatts.
no. You see, we are not going to go into this. This is for the appellate forum to decide. We can't go into this.
Inspection report say otherwise, my lord. That's why, my lord.
Well, respectfully, my lords, they have not even challenged the inspection report.
I challenge, my lord.
No,
But
my lords, may kindly see the prayer. They have not challenged
No,
the
no.
inspection.
You see,
It
no.
is not clear.
Mr. Soike, kindly. Your sanction load is 747 kVA, which is equivalent to 635. Right. 747 kVA, which is equivalent to 635. This is the sanctioned and the connected load.
Yes. As per the agreement, my lord.
Okay. So this is
Addition-
okay.
Addition-
Now, Mr. Soikia, wait. Kindly see the contract demand.
Yes, your lord.
Your contract demand is 485
85.
kVA. This is from March to November.
Yes, your lord.
Which is equivalent to how much? 485 kVA is equivalent to
My lord, 485, 412 kilowatt, my lord.
412 kW. And the other is 403 kVA,
342.55 kilowatt.
3
42.55 kilowatt.
point kW from December to February. Okay, now here, what are you saying?
I'm saying that
Where's the inspection report?
inspection report is at page, my lord,
Yeah,
45,
page 45.
45 of petition 81 of 24.
What does it say?
Here, my lord, total connected load shown 804 kilowatt. At
Huh?
page 46, my lord. Type copies, my lord.
Hmm.
At page 46. Total connected load detected 804 kilowatt.
Very. 804 kilowatt,
Yes, my lord.
which means how much?
Uh,
804, which means almost 300 kilowatt above, almost 400,
my lord,
300 and 390.
it may be higher than the kilowatt, my lord.
No, it is more than 390 kW
Okay.
above the contract demand.
Yes, my lord.
Then
My lord, at that time, my lord, my sanction load as per agreement was 635 kilowatt, and additional sanction load was 254 kilowatt. That is not released, my lord, but sanctioned.
what is this not released?
My lord, I like to draw attention to page number, my lord, 86.
No, can are not released.
I have used, my lord, I am.
No. You are to be, the unauthorized use of the electricity would be if it goes beyond the contract demand, not the sanction load. Because the sanction load, you must have taken the sanction. But you say, by entering into this agreement, that look here, because you see, whenever you are using the contract demand, that for that there is a minimum charge which is being taken by them. So therefore, it has to be on the basis of 485 kVA, which is equivalent to 412.
My lord, that is correct, my lord.
So therefore, you are having 804, meaning thereby 804 has to be normally multiplied by twice the tariff into 12 months. If it cannot be ascertained, 12 months, thereupon subtracted with the amount which you have paid for 412.
804 is the total detected load, my lord. It also includes the 635 that was allotted to him. In addition to that, my lords, there was a request on their part for an additional sanction of 253 kilowatt, which was sanctioned by the APTCL subject to payment of the requisite fees and execution of an agreement.
That was not done.
That was not done, my lord. The
So
agreement
therefore,
was never
we
executed.
won't look into that.
No, but that is also subject matter of the inspection, my lord. That has also been charged as an unauthorized usage, my lord. That portion of 253 kilowatt.
Where?
Yes, my lord. My lords, may kindly see page 56, my lords. It's an annexure to a load survey carried out, my lords.
Yes.
Starts at page 55.
As per the consumer's inspection on so and so, it was found that 6 numbers of different irrigation projects, as mentioned under the finding of load survey report, had provisions of drawing power from LT so and so, step up transformer and so in the higher HTF demand, violating the agreement of so demand. Thus, there is an excess load of 256 against the irrigation which is demand. 804 plus so this demand. Okay. So it has to be on 1057.
1057 minus 635, my lords.
No. Why is 635?
635 is the sanction load, my lord.
So you minus
No, my lords. I'm sorry.
on contract demand.
Yes. The contract.
So it will be minus with 412.
Yes. It would perhaps come to, my lords, 422.64.
Oh, how? 1057.64 subtract it with 412. How much it would be?
My lord, what my learned friends stated that I have not deposited, my lord. Kindly see at page 79, my lord.
How much it would be?
Multiplied by 20.
1057.64 minus 422, my lord.
Why 422? 485 kVA is how much? 412,
404.
isn't it?
Yes, ma'am.
412,
It will come to 645.64, my lord.
645, na?
Yes, ma'am.
645.64.
Yes.
Now, so this is the amount. So now what? Additionally, this was 645.
Additional was 254 kilowatt. Additional was 2
Total is 645
630.
because you have not entered into an agreement.
For 254, I have not entered into.
So that has to be taken into consideration.
Yes, ma'am.
And additionally, you have to take into consideration that on the date of the inspection, it was found
804. ma'am.
804 without these additional things being looked into, isn't it?
Yes, ma'am.
Are these things looked into?
My lord, my submission is that, my lord, physical connected load is not a subject matter of these categories consumers, my lord. Because, my lord, the contract demand is independent of connected load. It may be higher, it may be lower, my lord. If the contract demand is independent of connected load, on the basis of connected load, assessment cannot be made, my lord. Even when I have exceeded the contract demand, that may be come as per the apex court judgment under the unauthorized use of electricity, my lord. Only when I have consumed, and how much I have consumed is reflected in the digital meter, electronic meter, my lord. And when that is also in the electronic meter. That's why if the assessment made, my lord, only upon that quantity and that particular period they can do, my lord. Otherwise, my lord, physical connected load cannot be come into this matter, my lord. As because, my lord, the contract demand is independent from connected load. Already I have authorized to connected load for 635 kilowatt. I am using 485 kilowatt. Then, my lord, the connected load is higher. If the assessment made on that basis, my lord, it will, my lord, contradict each other, my lord, from the agreement as well as from the provision of 2.2.3 of the AERC regulation 2017, my lord. As per the AERC regulation 2.2.3, the contract demand is independent of connected load, my lord.
No. You are, if the moment you cross the threshold of the contract demand,
Yes, my lord.
it would be an unauthorized use of electricity.
Yes, my lord. I agree on that.
So therefore, your submission is, as the meter indicates, whenever there is an addition to whatever it is the contract demand, you say only that portion of it has to be multiplied by
Yes.
2.
Yes, my lord. That is liable for assessment, my lord. As per apex court decision, my lord, the Sitaram rice mill, my lord.
Let's see.
My lord. The last page, my lord.
Yes.
Para 87, my lord.
Wherever the consumer commits the breach of the terms of the agreement,
Yes, my lord.
regulations and provisions of air by consuming electricity in excess of the sanction and connected load.
Yes, sir.
So here it goes into sanction and connected load.
Yes, sir.
Such consumer would be in blame and under liability within the year 126.
Yes, sir.
Now here the 126, it is not beyond the connected load.
Yes, Your Lordship. Sanction load.
Here the sanction and the connected load is one and the same.
Yes, same, my lord.
So if you go beyond the sanction load, it is the same. But
contempt,
here,
my lord.
this does not say about contract demand.
Yes, my lord.
Now let's see number 2. Unauthorized as appearing in so-and-so is an expression of wider connotation and has to be construed purposefully in contrast to contractual area, while keeping in mind the object and purpose of the case of excess load consumption. Then the connected load inter alia would fall under the demand of the demand, besides it being in violation of so-and-so regulation. It's only final order of assessment. So here the court does not say anything about what you are saying.
My lord, here it's stated the cases of excess load consumption, then the connected load inter alia.
Understood, but the Supreme Court was not taking into consideration that the contract demand can be different from the connected load.
My lord, that is mentioned in the regulation, my lord.
Understood,
Yes,
but
my
you
lord.
have entered into an agreement.
My lord, otherwise the connected load doesn't come under the purview of the meaning, that is unauthorized use of electricity. My lord, section 126 of Electricity Act, my lord, has not speak about the connected load as unauthorized use of electricity.
Now kindly come to clause 7.4 F Roman 1.
My lord, in that regard, I want to submit that
No,
Yeah.
you see, no. The following acts on the part of the consumer shall also be considered as an unauthorized use of electricity and shall also be dealt with for assessment under increase in connected or contract load in excess of the sanctioned load as per the agreement, shifting of location of the meter so and so, tampering with so and so. Now, if that be so, increase in connected or contract load.
my lord, that is applicable only for the those consumers who have not maximum demand index meter, my lord. My lord, that's because my lord, clause 2.2.3, my lord, kindly have a look for a moment, my lord. Here, my lord, contracted load, contract demand and billing demand. Contract demand.
Page.
Page, my lord, of this book 16. Here, contract demand of a consumer shall be Roman 1, LT consumers without maximum demand base tariff. The contract demand for LT consumer without MD base tariff will be the connected load of the premises as per the agreement entered into between the consumer and the licensee. 2. LT consumer with MD based tariff and all HT and EHT consumers, the contract demand shall be as per the agreement entered into between the consumer and the licensee and having regard to the requirement of the consumers installation and will be independent of connected load. That is important, my lord. In this regard, AERC also explained, my lord, in an order.
No, the question is, in the instant case, as we see, it has not only gone excess to your contract demand,
Yes, my lord.
but it is in excess to your connected load also.
No,
Yes.
In this case, my lord, petitioner exceeded the contract demand, not the sanction load.
No. On inspection, it was found that you were using 1057.64.
My lord, from this clause 2.2.3 A, my lord, I understand that, my lord, the contract demand is independent of connected load, my lord. Connected load may be less or may be high, my lord. That is.
No,
the
I'm not
subject
there.
matter.
First of all, the contract demand has to be lower than the connected load.
Yes, my lord.
It cannot
It
be.
is there, my lord.
Now, connected load and sanction load are one and the same.
My lord.
There's no quarrel with that. The contract demand is a demand by which you come into an agreement that although I have a connected or a sanction load of so much, but I am only going to use this much.
Yes, my lord.
Now, in the instant case, you, by way of an agreement entered into on 17/7/2017, agreed that you are going to have a total contract demand of 412 kW, which is equivalent to 485 kVA in the peak season, and 342.55 kW in the off season, which is equivalent to 403 kVA.
My lord.
If that be so, you already had 603,
Yes, sir.
685, 635 kW. We already had.
Yes, lord.
What was the necessity for you to ask for more sanction when you are already having more than the contract demand?
My lord, that is because, my lord, since 2010, my lord, the authority has prohibited the diversion of factory load to the irrigation line, my lord. And
So you
for
have
that
made
irrigation
diversion also.
my lord. No, my lord.
You have also made diversion also.
No, my lord, no.
There's no diversion. From 2010, there was a demand for them for an extension of the load of it to the tune of 253 kilowatt for operating certain irrigation points. These were outside the scope of the original agreement. We had written to them that for this additional load, you have to execute an agreement and pay the requisite fee. Agreement, my lords, admittedly, in the reply also they've stated they've not executed the agreement. That 253.64 kilowatt that they wanted, they had been using it ever since without executing that agreement, my lord. That is
So
that-
therefore,
So
my
beyond the
question,
scope of
no,
635.
no, therefore my question is, why I'm putting this question in? Then the inspection which was carried out, and there was an additional found, which is shown as annexure 1 to that.
Yes.
That is a separate one, beyond that 804.
My lords, yes. That is the irrigation points.
So there's the irrigation. Now the irrigation, there was no inspection.
My lord, the irrigation points were connected to the mains that were
Understood.
installed by the APDCL, my lord.
But there was no inspection of the irrigation points on 22/7.
On
22/8.
22/7, no, my lords.
22/8, when the inspection was carried out,
Yes.
that was nothing to do with the irrigation.
No.
But at that point of time, it was also connected with the irrigation.
Yes. Perhaps, my lords, I cannot possibly.
So therefore, there will be two aspects. As you can see from this particular 7.4, kindly see this, unauthorized use 7.4.
Yes, my lord.
7.4D, use of electricity for the purpose other than for which the supply of electricity was given.
Yes.
So this additional which is being found is completely different from using in excess of this,
635.
which comes under 207.4 Roman 1 F1. This is going beyond the contract demand.
Beyond the sanction load.
So therefore, there will be two types of assessments.
If I may just point out, my lords, the
Because you see the N factor which is there. One is using this beyond the particular thing. And the agreement which was agreed on 17.7 is only for 485. There's a separate agreement for which he was asking to be entered into in respect to 256, which have not been entered. Meaning thereby for that particular work, they for using those 6 irrigation projects, there was use from a particular meter.
they were using to irrigate those 6 points. They were using the very same lines or the mains that had been installed under the agreement of 17.7.
Therefore, my question therefore is, this assessment as regards 7 point, the other 257 or whatever was found, has to be done as an unauthorized use of electricity under 7.4D. Whereas the area which has gone, the aspect which has gone above the contract demand, there it has to be done on the basis of 7.4 F1. So there, you have made the inspection. You didn't make the inspection there in those irrigations.
Okay. Not on 2280.
Yes. Therefore, for that additional thing, isn't he liable to pay as per 12 months?
My lord, kindly see the inspection
And for
report.
this,
Because
he
my lord,
needs to pay as per which he's saying when you have that meter.
my lord, respondent stated that it is connected, but inspection report says, can this supply? There is some generators who is provided electricity from the generator, my lord.
No,
It is
that
not-
was found.
Not the case of connection. my
No,
lord.
therefore my question is, these are two separate things.
Separate things.
So if it is separate thing, you need to ask him for the money for that
253 minutes.
into 12 months. The entire 253 into 12 months has to be, because he has not paid a single penny against it. How was he using this all along?
He was drawing powers to those points from the very lines installed under the agreement of 17.7. He was sanctioned 635. He was using the connected load as well as the 253 in addition. And the entire process was done in a way that the sanction load or the meter would never go on to show that the petitioner had exceeded the contract demand. So they generally what they
I
did.
think the appellate court was more kind to him.
My lord, kindly see the definition of sanction load, my lord, where simultaneously used, my lord, then only, my lord, it comes under the definition of connected load, my lord. And the meter, if the meter is same, my lord, it has not even exceeded the sanction load, my lord, which recorded everything, my lord. The maximum demand and in other hand, my lord, the consumption of energy, my lord. As the revenue module, my lord, there are two components. One is fixed, another is the consumption of energy. Whenever I have the petitioner uses any, my lord, load exceeding, my lord, that will reflect in the meter, my lord. That meter has
That will
reflected-
reflect after 30 minutes
After
of
30
running.
minutes.
Yes, my lord, 30 minutes. That is higher side, my lord. And until manually reset it, my lord, it will remain there, my lord.
That is again only as regards to the contract demand, my lord. It will not go on to show that whether he has exceeded 635.
No, their contract demand or sanction demand, these are not reflected there. The meter reflects only the maximum demand uses.
So the meter was also wrong, it appears, because for that you have shown me one bill during that period where it was found only a particular only high. Let's see the bill for the period, this period of 24 24/5/2018. This period you showed me the bill last time.
My lord, is it at page 80, my lord?
Hmm?
Item 26 for PG.
Page 80, yeah. 80?
Page 80, my lord.
Page?
80. The bill start from page 80, my lord.
Ah, this one. Now you see, this 80, 1/8/2017 to 31/8/2017. This is the period.
Yes, my lord.
Now here, while inspection was carried out, they found 1057.
Yes, sir.
But here it is not shown.
Okay, that point. I don't understand that point, my lord.
While carrying out the inspection, it was found that there was an increase by 804 in the main premises. And further, additionally, you have connected 257. Additionally, you have connected 257.
Conducted on 22nd of August 2017. Even if after that, the maximum load may high. my lord.
No,
Because-
not this one. This one. We are concerned with 5/8. Where's the April one? We are concerned with this period, na? 24/5.
Right.
24/5 bill.
my lord, 24/5. I have the bill, but I have not annexed it, my lord. For the month of May 2018, I have the copy of bill.
Where is it? Now here you see, as per this, there's no overdrawal.
No, my lord.
No overdrawal.
No, my lord.
So there, but on inspection, it was found that there is overdrawal.
Not inspection, I mean physical verification.
Huh.
Otherwise, my lord, I have.
Inspection has to be physical only.
No, my contention is on the meter, because whenever I consumes, then only it comes the connected to under the unauthorized use of electricity. my lord. As the
So
bill-
they have they found 804 and or totaling to 1057, taking into account the equipments which have been connected,
Yes, my lord.
but not on the running of the meter, all.
All are through same meter, my lord.
Just for example, out here,
Yes.
you have 4, 3, 4. This is 4, 5. So total is around 8, 13. Now against this 13, you have, for using all this 13, you will require 100.
Yes.
But your connected load is 60.
Yes, my lord.
So the equipments which are connected out here, all together measures 100. If you burn, you switch on all.
Yes,
But
my lord.
what you switched on is only for 5.
Yes.
Thereby, it is 40.
My lord, the reason behind it, my lord, the machineries used in the tea garden, my lord, has not used simultaneous.
Understood? So this is against what is being connected.
That is correct. But my lord, as per the provision of 126, 6, Explanation B. The connected load directly not come under unauthorized use of electricity. Only when I consumes, then only come unauthorized use of electricity, my lord. Because of that, I refer to the judgment passed by the Tiran Rice Mill, my lord. My lord, reason behind has explained.
Wherever the consumer commits the breach of the terms of the agreement, regulations and provisions of the act by consuming electricity in excess of the sanction and connected load, such consumer would be to be blamed. So therefore, you are saying that though these machines are being connected, but I don't go beyond the contract demand.
Yes, your lord. Sanction load.
Sanction load is okay. Because here we find, although you have a connected machines of 1057 kW, but what was used out there in that month, the highest which went was less than, would be around 350 kW. The page which you have given, you see RD, MD,
0.44.
442.
440 is MD, my lord.
What is MD?
Maximum demand.
That is it. 442. So 442, this is kVA, would come to around 350 kW.
Yes.
But you had a connected load, connected machines of 1057. This is what was found in the inspection.
My lord, even then, I disagree that 254 kilowatt was connected, my lord. I agree that 804 have found connected, my lord.
So my question therefore is
Understand, my lord?
that what was found connected was 1057.
No, 804, my lord.
There is another 257.
54, my lord.
So therefore 1057 was connected. Machines were connected, but not used. But not used.
Maybe.
Not simultaneously used, but you had this. Just for example, that is why I'm saying this, all these 13 lights you had. Your connected contract demand was 60. And what you used was 40. Now you are now being asked to pay. As you had the contract off, you had connected these 13 lights.
Let in this regard, I like to draw to the paragraph number 67 of the Apex Code Judgment, my lord. My lord.
But Mr. Saike, am I right?
My lord, your lordship is right in one way, but other way.
No, my question is this. These are, you had 1057. There's no quarrel with that.
I have disputed that, my lord, because I have not connected the 254 kilowatt.
You have not connected is different, but you had machineries of 1057.
It is completely different drawing, different connection, my lord.
But you don't have a connection for that.
Yes, my lord.
You were,
Only thing is that, my lord.
no, Mr. Saike, you were using the same connection.
No, my lord.
Because they didn't give you a connection for that.
Yes, it was never signed. It was
So
never signed.
therefore, that 200, for those 6 machines,
Is that fact is that, my lord, till 2010, since 2001, my lord, diversion was there. That line was existed since 2001, my lord. When the authority prohibited from diverting, since then we have used generators to supply the electricity for that line, my lord. And another thing is that, my lord, when the
no, Mr. Saike. Mr. Saike. No, Mr. Saike. Then, no, Mr. Saike, I'm not going to enter into that dispute. No, Mr. Saike, this is in finality, I'm not going to.
my lord,
We have to accept that 1057 were the machines which were connected. This is a finding of fact which I'm not going to touch. You cannot bring this court to do 1057. Now the question is, you did not use all these machines together
yes,
and thereby did not go enhance beyond the contract demand. So therefore, your case is that there is no violation.
Yes.
That's your case. But the question is, there is an unauthorized use of electricity here, taking into account 7.4.b. 7.4.2. 7.4b.
Yes, my lord.
Use of electricity for the purpose other than for what which the supply of electricity was given.
Yes.
This is a finding of fact, Mr. Sekia.
Finding of
Fact.
fact, my lord.
No. I mean, Mr. Sekia, I'm not going to go into that. So therefore, there was a use by around 257 kW of machineries there as per 7.4b D. Your submission out here, taking into this, is that look here, it would be a case of unauthorized use of electricity if there is a consumption of electricity in excess of the sanction or connected load. But there is a contract demand, which is not the subject matter in Sitaram's case. So here you enter into, but one thing it mentions very categorically, that if there is a violation of the agreement also, it would amount to violation of the agreement entered into will also amount to unauthorized use of electricity.
In that case, that thing was discussed, my lord.
So therefore, here there is no unauthorized use of electricity beyond it. You have not surpassed the contract demand. But what was the problem with you was you have connected certain machineries to the connected load without using them. Would that be unauthorized use of electricity? Yes. In view of 7.4.2, 7.2. It is so. There's no quarrel with that.
Yes, something.
But how do you calculate it?
My lord, can you see the paragraph 67 of Apex Court judgment, my lord?
Mr. M.K. Chaudhary, this matter, I've been hearing Mr. Saikia so many times. But till now, I'm still not clear. What is it? All the matters which were tagged along with this have already been disposed of. Only thing remains. You see, the matter pertains to which I can get it here as of now is he has a connected load. He has machineries which were connected to the connection of around 1057 kW. But he has not used it beyond the contract demand. It is. Taking into account this regulation, it is. It is. But how do you calculate it? Now, what they have done it, they have calculated this 1047, 57, whatever it may be, minus the sanction load, coming into around 422, and then multiplied into 12, multiplied into 2 into 12 months. Now, on the earlier occasion, I said, how do you multiply into 2? Into 12 months, taking into account there is a calculation which says that n means even a fraction of a month also. So it is shown that there is an unauthorized use of the electricity beyond that. Now, this aspect cannot be seen in the meter because of the fact he has not used it. He has kept all these machines together, but he has not used it. Now, but if he had used it, he pays less. But if he has not used it, can he pay more? So that is the problem which this court is faced.
Yes, sir.
If he has used, if those all these 1057 meters all are being used, then he will be paying as per how much increase. If all are connected and used, then he'll pay how much additional it is. And then they will be charging it. But if he doesn't do it, he'll have to pay more. That cannot be so. That is the dilemma in which this matter is going on for such a long time. Yes, 67.
67 here, my lord, is stated on the cumulative reading of the terms and conditions of the supply, the contract executed between the parties and the provisions of 2003 Act. We have no hesitation in holding that consumption of electricity in excess of the sanction connected load shall be an unauthorized use of electricity in terms of section 126 of the 2003 Act. This we also say for the reason that overdrawal of electricity amounts to breach of terms and conditions of the contract and the statutory conditions. Besides such overdrawal being prejudice to the public at large, as it is likely to throw out of gear the entire supply system, undermining its efficacy, efficiency, and even increasing voltage fluctuations. My lord, it comes when the petitioner consumer uses electricity, my lord. Otherwise, the respondent official will not suffer anyway, my lord. Because the Act, 2003 Act is revenue centered, my lord. In addition to that, to protect the consumers, my lord. As it reflects in the preamble, my lord, that also enacted for protect the consumers. As such, my lord, when the consumer has not uses in excess to the contract demand, my lord, that will not.
Mr. Chaudhary, there is a provision out here, no, by which it is clearly.
Yes, if I may just point
Yes,
out one
yes.
thing, perhaps it will help my lordship in deciding on this issue. My lords, may I kindly have page 40 of item number 25. It provides for a list of electrical equipments connected at the time of execution of the agreement. 840, my lords. It is a continuation of the agreement, my lord.
Yes.
My lords, here is a list of all the electrical apparatus that was connected at the time of execution. Here, my lords, there is no.
This is 2010.
As on 2010. This has not changed. This is the document that they have relied upon. Now, my lords, what I wanted to point out was, my lords, in the list of equipments, there is absolutely no mention about any generators or any irrigation mechanism, machinery, my lords.
Yes.
Now, if my lord kindly.
Now, see, kindly come to page 44
I'm sorry, my lord.
of that document.
44, my lord. 44. Yes.
Here, total connected load is 634.
Yes.
So, sanction load is different. So, we have to understand, sanction load is which you sanction it.
Yes.
Connected load is the apparatus connected to the epidicial line.
Yes.
What? So, these are not akin. Sanction is as per agreement. Connected is what are the machines which are connected. And how can then you have a contract demand less? My question is this.
When
You
it
see,
comes to industries
if
of
we go by this page 44,
yes,
total connected load is 634.172 kW. Meaning thereby, it is 635. That is what you have given.
635.
635 you have given.
Yes.
Which comes to 747 kVA.
For 7.
Then why on earth did you give that 485 kVA as the contract demand?
But this is only with regard to industries of this nature, or seasonal industries, my lords. Like
So
tea
therefore,
industry. Yes.
the machines being connected with the epidicial line, even more than the contract demand, cannot be the ground for imposing a penalty upon him. What can be the ground for imposing the penalty is if there is an overdrawal beyond that, or if it is more than what is connected. If the connection load is more than the sanction load, then it is so. Just for example, I have a 15 kilowatt sanction load. I connect 21. So then there's a violation. But if I have 15 and I connect 15, but I have a contract demand of less than 10, then on the basis that it is more than 10, you cannot charge him. But as you could find out 1057, 1057 is the connected. Now the question is, if 1057 is the connected load, you has not used it. So the contract demand aspect goes away. So the sanction load is 635. So the difference is around 422 or whatever may be, is the amount on which he is using a connected load beyond the sanction and thereby liable. Now show me how it is liable as per clause 7.4.
As far as the 635 kilowatt and the contract demand in question is concerned, that will perhaps, my lord, has already fallen from my lordship, my lord. We'll have to perhaps limit it to the period where they have been overdrawn. It cannot possibly be for 12 months. That has to be reduced, keeping in view the inspection of 22/8 going up to the latest inspection, which is the subject matter of this.
Now, understood. No, now my question is, when a contract load, connected load exceeds the sanction load, that is also unauthorized. Means this is unauthorized connected load. So that portion of it, 422, is the unauthorized connected load.
That 422 again is divided, man. There is that 253.
Understood. But whatever may be, all are counted. 1057 minus 635, they have reached to this 422. So therefore, this 422 is the unauthorized connected load to the sanction load of 635. Let's make it simple. Now against this, as on 22/8/2017, you did not find anything. Now show me when there is a connected load above the sanction load, or which means a connected and unauthorized use of unauthorized connection of a load beyond the sanction load, which is as per the agreement. Sanction load is the agreement. It would lead to unauthorized use of electricity. And how you are going to count it?
Why I wanted to point out, my lord, this the list of equipments at page 40. My lords, because for the reason, my lords, at page, if my lord kindly takes up the supply code at page 107, clause 9.110. 9.10.
107.
It's page 107, clause 9.10.
Uh.
Should the consumer at any time after the
Uh-huh.
supply
Oh, which book? Oh, this book.
of the supply code, my lord.
107. Yes.
Should the consumer at any time after the supply of energy has commenced desire to increase the number of size or lifespan motors, etc., or add new appliances such as so and so, in his premises or any way, alter the position of his wiring therein, notice thereof, and we need to change the connected load, if any, shall be sent in writing to the licensee. If as a result of such proposed extensions and alteration, there is a possibility of increase in connected load
Over the sanction limit. That is what I'm saying.
over the sanction load, action as specified under this clause 5.8 of it shall be taken.
Take it. Failure to regularize in the increase of air will be treated as unauthorized use. So therefore it is there.
Yes.
This will be air.
Yes.
But how do you calculate it? This is the answer. That page 44 was the answer. Yes, which one? How do you calculate? We have it at 2. Let me know how will you calculate this? Because if we see 7.4, yes. In the assessment in case of unauthorized air, change of category, resale of air, B, demand charge in case of excess unauthorized load. So this is it. So it will be 2C into B into D minus D. So this will be as per 7.4.2 Roman 2, Roman 3, A. So it has to be done in that. So therefore, these two, so it is only for this 422, because this is in addition to that. And then there is no subtraction out here because he has not paid.
That provision for
422, there is
without
no
any-
subtraction.
That is for without and the income. That provision is for without any income.
No. Demand charge in case of excess unauthorized load. You are not in case of MDA meter. I'm saying about demand charge in here. Because MDA meter is not there in the scene. We are not to look into. Here we have to therefore limit it from 22.8.
Is limited more.
So 422. Only for that. That is enough. So your time therefore comes from 22.8 2017 to 24.5 2018. 422. That is it. This is what I came up in the first stage. And you tried again to confuse me with this. No, I'm today finishing it off and by dictating this judgment. Okay, this has to be finished. So this period, because it is not on the basis of the meter reading. Because he has not used it. It is an unauthorized connected loop. And you cannot ascertain for 12 months. So we therefore say it for around 7 months. Anyways, he saves a lot on that also. But Mr. M. Soikia, the learned counsel appearing on behalf of the petitioner in both the writ petitions, and Mr. B. Chaudhary appearing on behalf of the respondents in both the writ petitions. It is not there. Both the writ petitions are interrelated and as such taken up for disposal by this common judgment and order. Preface. The petitioner have essayed the order passed by the appellate authority dated 8/12/2023 in appeal number 4/2023 in WPC number 81/2024. The reassessment bills so prepared in pursuance to the order passed by the appellate authority dated 8/12/2023 in appeal number 4/2023. That is the bill dated. Where is the bill?
At page 79 of WBC number 646 of
Where
20.
is the bill dated? Where?
At page 79 number.
30/12/2023 is the subject matter of challenge in WPC number 646/2024. Brief facts. At least state in the name of Rose Candy Tea, in the name and style of Rose Candy Tea State, is a consumer of the Assam Power Distribution Company Limited, in short APDCL, under the Kachar Electrical Circle since 1978 in the category of HT, tea, coffee and rubber, etc. It is relevant to take note of that in the year 2010, an agreement was entered into by and between the Rose Candy Tea State, hereinafter referred to as the Tea State, petitioner's Tea State, with APDCL. In terms with the said agreement, dated 2/9/2010, the sanction load was 747 kVA, which is equivalent to 635 kW. The connected load was 746 kVA, which was equivalent to 634.061 kW. Taking into account that the petitioner's tea state falls within the category tea, coffee, and rubber, the seasonal contract demand was 485 kVA, which is equivalent to 412 kW. This seasonal contract demand was for the period from April to November. For the purpose of during the off-season, the agreed contract demand was 300 kVA, which is equivalent to, if that amount, let's find out. Huh? Yes. The off-seasonal contract demand was for the period from December to March. It is very pertinent to take note of that at the time when the agreement was entered into on 2/9/2010, the list of electrical connected load as on 7/10/2010 was furnished, wherein the total connected load was shown as 634.172 kW. The said list of electrical connected load is a part of the agreement dated 2/9/2010, which is Annexure 2 to WPC number 81/2024. It is further relevant to take note of that in the year 2017, another agreement was entered into by and between the petitioner's tea state and the APDCL, whereby the sanction load was 747 kVA, that is 635 kW. Connected load was 747 kVA, bracket 635 kW. And the contract demand, seasonal contract demand, was 485 kVA and the off-seasonal contract demand was 403 kVA. At 485 kVA against the likhibo bracketot dibo 412 kW and 403 kVA bracketot likhibo 342.55 kW. An inspection was carried out on at this stage, it is very pertinent to take note of that after the agreement was entered into on 38,
31st August.
on 17/7/2017, an inspection was carried out on 22/8/2017. The report of the inspection has been kept on record and marked with the letter Y on the basis of an order passed by this court on
Third February.
Yeah.
Order date is 3rd February.
3rd February.
Of February.
The said document is kept on record and marked with the letter Y. In terms with the said inspection so carried out, it was found that a connected load was 635 kW, corresponding to 747 kVA. The materials on record further show that on 24/5/2018, an inspection was carried out in the petitioner's estate, and it was found that within the premises of the petitioner's estate, the total connected load was 804 kW. In addition to that, it was also found that there was excess load drawal of 253.64 kW against irrigation. Accordingly, the total detected load was 804 kW plus 253.64 kW is equals to 1057.64 kW. On the basis of the said inspection carried out, a provisional bill was raised. A provisional bill was submitted to the petitioner under Section 126 of the Indian Electricity Act 2003, for short, the Act of 2003, on 14/6/2018, thereby assessing that the petitioner was liable to pay an amount of rupees 54 lakhs 65,000 and 23 54,65023. The petitioner challenged the said, filed objection against the provisional assessment. The final assessment bill thereupon was made. This is approving the same final assessment.
Yes, my lord.
Where the final assessment bill?
My lord, that is 98.
Objection. So thereupon, an order was passed by the assessing officer on 26/9/2018, whereby the amount, the provisional assessment amount was reduced to rupees 55,75,000 and 045 in words linking. The petitioner thereupon, being aggrieved, preferred an appeal before the appellate authority under Section 127 of the Act of 2003. The appellate authority, by an order dated 8/10/2018, did not interfere with the final assessment bill.
Did interfere.
Huh?
The,
Oh, this is different. Where is that order?
It starts at 126, page 120.
The appellate authority, by an order dated 8/12/2023, interfered with the final assessment bill by opining that the final assessment bill was prepared in respect to the entire detected load of 105.7.64 kW at twice the rate for 12 months, less already paid fixed charges for the period. The appellate authority held that the assessment bill should have been made only as regards the excess load detected of 422.64 kW, bracket 497.22 kVA, instead of 1057.64 kW, bracket 1244.28 kVA. Accordingly, the appellate authority, by the impugn order dated 8/12/2023 directed that the reassessment bill be prepared on the quantum of the excess 422.64 kW bracket 497.22 kVA load found connected for a period of 12 months at double the tariff prevailing at the respective period. It was also observed that if any advance payment and other overdrawal penalty were recovered from the appellant during that period of 12 months, the amount shall be deducted from the said bill. Petitioner being aggrieved, file WPC number 81/2024, challenging the said order dated 8/12/2023. The record reveals that this court, by an order dated 10/1/2024, issued notice It is further seen from the records that on 30 on 18/1/2024, the Assistant General Manager, IRCA PDCA, Meherpur, had served the revised reassessment bill dated 30/12/2023 upon the petitioner. In terms with the said revised reassessment bill, the total amount the petitioner was liable to pay was rupees 12,60,063. The second writ petition was filed by the petitioner. The second writ petition, that is the WPC number 646/2024, was filed by the petitioner, challenging the reassessment bill dated 30/12/2023. The record reveals that this court, by an order dated 9/2/2024, passed an interim direction that the final bill dated 30/12/2023 shall not be acted upon, subject to the condition that 50% of the said bill is paid to the respondent authority within a period of 10 days. Okay? It is further relevant to take note of that pursuant to the said order dated 9/2/2024, the writ petition was again listed. The writ petition being WPC number 646/2024 was again listed on 19/2/2024, whereby a receipt dated 16/2/2024 a payment of rupees 6,30,032 was produced before this court, and this court issued notice making it returnable by 4 weeks. We have filed affidavits.
It's in the first matter, 25 by the.
This court have duly taken note of that in pursuance to the notice being issued in both the writ petitions, pleadings have been exchanged between the parties in WPC number 81/2024. The respondent in the said in their pleadings have supported the impugned order dated 8/12/2023 on the ground stating inter alia that the same was done in accordance with the provisions of the Act of 2003, read along with the AERC Electricity Supply Code and CEA Installation and Operation of Meters Regulations. Recorded there here enough to refer to as the regulations. Submissions made on behalf of the response, on behalf of the parties. Mr. M. Sekia, the learned counsel appearing on behalf of the petitioners, had submitted that the learned appellate authority had erred in law in taking into consideration that there was an excess load of 422 0.64 kW without taking into consideration that these excess that the load, without taking into consideration that the machinery, that the electrical equipments in respect to the 6 irrigation projects were actually connected to the generators, and as such, the same could not have been taken into consideration while determining that there was an excess load of 253.64 kW. The learned counsel for the petitioner further submitted referring to the judgment of the Supreme Court in the case of Sitaram Executive Engineer Southern Electricity Supply Company of Orissa Limited, South Coast, and another versus Sitaram Rice Mill, reported in 2012 to SCC 108, that it would be a case of unauthorized use of electricity in the circumstance where there is a consumption of electricity in excess of the sanctioned and connected load. The learned counsel referring to the various bills submitted, that these connections that the petitioners state, the meter of the petitioner was an MDI meter, and as such, it can be very well noticed as to what was the maximum demand. He therefore submitted that when it is a case of, it is only when the petitioner had exceeded the maximum demand beyond the contract load, contract load, the petitioner can be only penalized only to that extent and not beyond that. He therefore submitted that the directions so passed in the impugned appellate order that the petitioner has to be imposed with electricity duty for excess 422.64 kW is not in consonance with the judgment of the Supreme Court in the case of Sitaram Rice Mills, Sri Sitaram Rice Mills. Anything more?
Yes, look, in addition to the clause 7.4.2, Roman 1, C, Miller, where it stated wherever electronic meter are installed and the load curves are studied periodically, the period of unauthorized use of electricity could be limited to the exact period as could be determined scientifically.
Where?
My lord, at
7.4.
0.2, Roman 1, C.
C. The learned counsel further submitted, referring to clause 7.4.2, Roman 1, small c of the regulations, that wherever electronic meters are installed and load curves are studied periodically, the period of unauthorized use of electricity could be limited to the exact period as could be determined scientifically. He therefore submitted that as MDI meters were fitted to the petitioner's T-state, the said load curves could have been the period of unauthorized use of electricity could be limited to the exact period as could be determined scientifically. He therefore submitted that the methodology of assessment of the demand charge in the case of excess/unauthorized load has to be computed by taking into consideration clause 7.4.21 bracket C of the regulations.
In addition to that, Mallard, another clause, Mallard, that is 2.2.3, where it is stated the contract demand is independent from connected load.
We are not concerned with that contract demand. Enough. 3 submissions is
That may be a question submission, Mallard.
not there. Mr. B. Chaudhary, the learned counsel appearing on behalf of the respondents, submitted, fairly submitted, that taking into account that the inspection was carried out on 22/8/2017, and it was found that the connected load and there was nothing found against that the petitioner had unauthorized load, the impugn order has to be, the impugn order can be modified to the extent of, for the period after 22/8/2017 till the date of the inspection. The learned counsel submitted, referring to clause 5.8.1, which clause? 5 point? And then 9.8.1, referring to clause 9.10 of the regulation, and submitted that till regularization of the increase in the connected load, the excess and unauthorized load so connected has to be treated as unauthorized use of electricity. And the petitioner in the instant case was found to have excess and unauthorized connected load to the tune of 422.64 kW on the date of inspection carried out on 24/5/2018. He therefore submitted that under such circumstances, the assessment is required to be carried out in terms with clause 7.4.2 Roman 3, capital A. The learned counsel appearing on behalf of the APDCL further submitted that the submissions were made by the learned counsel appearing on behalf of the petitioner pertaining to clause 7.4.2 Roman 1C appears to be misconceived, taking into account that the instant case is a case of unauthorized oblique excess load and not a case of unauthorized use of electricity. No, unauthorized, not a case of use of electricity beyond the contract demand. He therefore submitted that as the petitioners herein have installed electrical equipments which was upon inspection was found to be 1057.64 kW, which is much beyond the sanction load of 635 kW. The impugn order so passed directing to assess the unauthorized oblique excess load of 422.64 kW calls for no interference. The learned counsel further for the respondents submitted that both the assessing officer as well as the appellate authority, which are authorities deciding findings of deciding facts, who are authorities, who are fact-finding authorities, having reached the conclusion that there was there was connected that electrical equipments were connected to the tune of 1057.64 kW. This court may not like to interfere with such finding of facts unless a case of gross perversity is shown. The learned counsel submitted that the materials on record would clearly show that it is an admitted fact that the petitioner had connected beyond the sanction load. And as such, the findings of facts who arrived at calls for no interference. This court have duly heard the learned counsels appearing on behalf of the parties and have given its anxious consideration. The materials on record clearly show that the petitioner had a sanction load of 747 kVA, which is equivalent to 635 kW. The connected load as on 17/7/2017 was also 747 kVA, bracket 635 kW. This court finds it very pertinent at this stage to take note of the definition of connected load as defined in clause 1.4.1.22 of the regulations, and the same is reproduced hereunder. A perusal of the above quoted definition shows that the connected load means the aggregate of the manufacturer's rated capacities of all energy consuming devices or apparatus connected with the distribution license service line in the consumer's premises, which can be simultaneously used and shall be determined as per the procedure laid down in the regulations. It further stipulates as to how the kVA is to be converted to kilowatts kW. Clause 1.4.1.26 defines contracted load or contract demand, and the same is reproduced hereunder. A perusal of the above definition would show that the maximum demand in kVA agreed to be supplied by the licensee and indicated in the agreement executed between the licensee and the consumer is the contract demand. It also stipulates that in case no agreement is made, the connected load will provisionally be treated as a contract load, contract demand, till agreement is made. Clause 1.4.1.68 defines the term sanction loan, and the same is reproduced hereunder. A perusal of the above clause would show that the sanction load means the load in KW, KVA, which the licensee has agreed to supply from time to time. Where is the clause by which it can change for the purpose of it can keep on changing? I looked into it. When the case of 2.2.2, yes. This court also finds it very relevant to take note of clause 2.2.3 of the regulation. Which relates to contract demand, taking into account that the petitioner is an HT consumer. HT, na? Clause 2.2.3 A, small a, Roman 2, small b, is relevant, and the same is reproduced hereunder. A perusal of the above quoted clause would show that a contract demand of a consumer may be revised once in a year. However, in case of seasonal industries such as tea, coffee, rubber, etc., the consumer may declare maximum of 2 seasonal contract demands in a year, one for season and for off-season period. In the backdrop of the above, let this court now take into account the agreement which was entered into by and between the petitioner as well as the APDCL authorities on 17/7/2017. The contract demand, the sanction load of the petitioner was 747 kVA, that is 635 kW. The connected load, meaning the apparatus, electrical apparatus which are connected to the connected with the distribution license service line, with the APDCL service line, was also 747 kVA, bracket 635 kW. Taking into account that the petitioner was a tea industry, the seasonal contract demand was 485 kVA during the period from March to November, and the off-seasonal demand was 403 kVA, that is from December to February. This court duly also takes note of the inspection report dated 24/5/2018, wherein it is seen that against the sanction load of 635 kW, the petitioner had electrical apparatuses and its consuming device or apparatuses had various consuming devices and apparatuses connected to the epidicial's service line. To the tune of 804 kW. In addition to that, it was also found during the inspection that six numbers of different irrigation points having a load of 253.64 kW was also connected with the epidicial's service line in the petitioner's premises. Therefore, from the above, it would be seen that against the sanctioned load of 635 kW, the consuming device or apparatuses connected to the epidicial's service line on the date of the inspection was 1057.64 kW. This court finds it very pertinent to take note of clause 9.10 of the regulation, which stipulates that if there is any increase in the connected load over the sanction demand, the consumer is required to take action in terms with clause 5.8.1 for regularizing the excess connected load. Failure to regularize the increase in the connected load would be treated as unauthorized use of electricity. Clause 9.1.0 being relevant is reproduced hereunder. The learned counsel appearing on behalf of the petitioner, though submitted that the 6 irrigation points were not actually connected to the epidicial's distribution line. Rather, it was connected to generators. It being a finding of fact arrived at by the fact-finding authorities, and nothing could be shown that such fact-finding, could be shown that the basis on which the facts were right were perverse. This court cannot, in exercise of the powers under Article 2 to 6 of the Constitution, sit as an appeal over such fact-finding issues. The such fact-finding decision. Therefore, from the above, it is apparent that on the date on which the inspection was carried out, the competent authority found that there was that consuming devices oblique apparatuses were connected with the epidicials service line to the tune of 1057.64 kW. The sanction load being only 635 kW. The non-regularization of the remaining beyond 635 kW as per clause 9.10 as above quoted would be considered as unauthorized use of electricity. The resulting effect of the above is that the petitioner had 422.64 kW of unauthorized oblique excess load beyond the sanction load. The learned, this court further takes note of that the learned appellate authority had come to that conclusion that the petitioner should be charged in terms with clause 7.4.3 7.4.2 Roman 3A.
I think this number should not be given because it is after amendment, my lord. Earlier it was 1.3.1. At that time of inspection, it was 3.1.
Ah. 3.1. 3.1 কৰিব আগতো এই 1 হ'ল। On 422.64 kW. For the purpose of the question therefore begs, the question therefore arises as to whether the learned first appellate authority could have directed the demand charge to be computed on 422.64 kW for a period of 12 months at double the tariff prevailing at the respective period. For understanding the same, it is very pertinent to take note of clause 7.4.2 Roman 3.1, which is reproduced herein under page 5061 of this. The method by which the demand charge is to be computed in case of excess oblique unauthorized load is duly mentioned. The variable n so mentioned in the formula mentioned in clause 7.4.2, Roman 3.1, as quoted above, is the number of months, comma, duly taking account of the fraction of a month. In other words, the period would depend upon inspection being carried out and the authorities having information regarding excess oblique unauthorized load. At this stage, this court finds it pertinent to take note of section 126. Five of the Act of 2003, which stipulates that when the assessing officer reaches to the conclusion that there is unauthorized use of electricity had taken place, the assessment shall be made for the entire period during which the unauthorized use of electricity had taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. It seems that the learned appellate court authority was not informed during the course of the hearing that there was an inspection carried out on 22/8/2017. And as such, on the basis of section 126, 5 of the Act of 2003, the variable N was put at 12 months. However, the inspection report dated 22/8/2017 clearly shows that on that very day there was no connected load in excess to the contract demand, excess to the sanction load. Therefore, there is a requirement of interference, the requirement for interfering with the impugned order, insofar as directing the assessment to be carried out by applying the variable N to 12 months, by 12 months, instead of the period after the inspection was carried out, that is on 22/8/2017. This court also finds it very pertinent to take note of the hearing which was conducted by this court on March 2026, when Mr. S. Bose, DGM, Commercial and Revenue APDCL, was present. He submitted during the course of the hearing. That for ascertaining the variable n, the assessing officer duly takes note of various aspects as regards when the apparatuses which were connected to the line of the epidicial, service line of the epidicial, were purchased. Or further inquiries are being carried out. Or submitted that for ascertaining the variable n, there are various inquiries can be made, including an inquiry by which inquiry as to when certain the apparatuses which were connected to the epidicial's service line were purchased. It is the opinion of this court that taking into account that the inspection was carried out on 22/8/2017 and there was no infringement found in the petitioners, and there was no infraction to the Act of 2003 as well as the regulations found on 22/7/2018. The assessing officer would be required to carry out a further inquiry as to how the variable n would be applied in the present facts, in as much as the same has to be subsequent to 22/8/2017 and prior to 24/5/2018. Accordingly, this court therefore disposes of the present petition with the following observations and directions. The impugn order dated 8/12/2023 passed by the appellate authority is interfered with only to this extent of directing the variable n to be used as 12 months, taking into account that on the date of the inspection on 22/7 to 22/8/2017, there was no violation to the Act of 2000. There was no unauthorized use of electricity found. Number two. The impugned assessment bill, reassessment bill dated 30/12/2013, 23, 23. It's also interfered with first, number three. The assessing officer, who is the respondent number? 5. In both same,
Same.
is directed to carry out, make necessary inquiries as to how the variable n can be applied in the present facts, in respect to the present dispute, while computing the demand charge for unauthorized excess load. For the sake of clarity, this court observes that the unauthorized load excess load is 422.64 kW. And this court further directs the assessing officer that after making necessary inquiry, apply the variable n, which is the number of months, duly taking account of the fraction of a month. And thereupon, issue a fresh assessment bill to the petitioner. Next. It is further observed and directed that in the circumstance, the fresh assessment bill so prepared pursuant to the directions above is less than the amount the petitioner had already deposited pursuant to the orders passed by this court. The remaining amount shall either be refunded or adjusted against the bills of the petitioner. Next. It is further observed and directed that in the circumstance the amount so deposited that in the circumstance the petitioner has in the circumstance upon reassessment being made pursuant to the above directions and an assessment bill is submitted where the amount is higher to the amount which the petitioner had already deposited, the respondent authorities would be at liberty to take such course of action as provided under the law. It will set aside for impugn beacon. See, Mr. Seke, I gave you everything. At last.
Make this adoption.
File an affidavit today. maybe taken up next week because we have brought our all stand on record, all communication is on record.
That is correct. But so far as what is to be done in the betwixt period, that is not there. They have primarily taken a stand that in terms of the pension rules, provisional pension is what I get. And I do not dispute that. What I was on is that during my service period, the financial benefits which have been granted to me on count of my promotions with retrospective effect, that has not been released. And the authorities have validly raised a query that if supernumerary posts were created, then there is a in-between period, which they have termed as a betwixt period. How do we treat that period? This reply is not even forthcoming from the finance department. Department
Anyways,
itself.
let's see the affidavit.
Yes, yes.
It has been submitted that the respondent in the forest department have filed the affidavit in opposition. The same is not tagged with the records. This matter again on 27th of March 2026. Liberty given to the petitioner to file reply on or before 26th of March 2026. The registry shall bring on record the said affidavit. Yes, what is this?
Your Lordship, this is a review application prepared by the against your Lordship.
In this case, Your Lordship, although Your Lordship, we have, it's a review petition, we are not seeking review on merit, Your Lordship. Your Lordship, the initial prayer was for regularization, Your Lordship. Your Lordship was pleased to hold that at this day, as it stands on that day, Your Lordship, that direction cannot be issued, Your Lordship. And finally, Your Lordship directed, observed that allow to give us providers the liberty to file a representation, Your Lordship.
Now tell me,
Lord.
who you are appearing for?
Go.
You are respondent number 5.
No, 5 is.
Now we want, Your Lordship.
Now, respondent number 5 I directed. You are appearing for? So they are not working under you. You are under NEPCO.
NIPCO, Your Lordship.
Huh?
What has happened, Your Lordship? Well, there is a we have, Your Lordship, failed to bring to the notice of this court that in the meanwhile, Your Lordship, from Tipaimuk project under NIPCO, we were shifted to Procedural project, Your Lordship. The same under NIPCO, Your Lordship.
Mizoram.
Mizoram, Your Lordship.
That's by NEPCO.
NIPCO, Your Lordship. NIPCO. And Your Lordship has, if Your Lordship may kindly come to Your Lordship's direction for a moment. Para 13, page number 38, Your Lordship. It was not even a direction, Your Lordship. Now these people, Your Lordship, just before retirement, Your Lordship, wanted to file that representation, Your Lordship. If they consider, and if not, then
With regard to working at, Your Lordship, this Tipamuk project, from there, NIPCO has come out in 2009.
It's okay.
Now.
No. They were, see, were they working under you? Did you initially appoint them?
No, they came from Brahmaputra board to us. And they were working in the Tipamuk project under NIPCO way back from 1999 to 2009 till when we were there in the project.
Okay. So,
After that, I don't
at
have
that
this.
point of time, they were there. So these directions, we review it to the extent that it should be now applicable to NEPCO.
that much, not more than that.
Provided, because they're pleading neither in the writ nor in this review petition, for the first time, he is submitting that they are working in Turi. That instruction, I don't.
It is to the.
That, it's
That is
nowhere
not there,
mentioned.
Your Lordship. It's
In the
high.
review petition, rather para 5, if your lordship just have a look, they are saying page 10 of the review petition.
Yes.
Page 10, it is stated by the petitioners that the petitioners are continuously discharging their duties as masteral worker at Tipamuk project. It is not about,
It's okay, but Tipamuk, you took it.
we took it, then government of India took it from us, gave it to NSPC.
Okay, but
Then it never, we
you,
handed it
you,
over.
you gave it to them
Then,
after completion. After completion.
no. It was in the development stage. Your lordship may just turn to their affidavit for a moment, your lordship. Our affidavit, your lordship, page, Annex 4. 107 maybe just seen, your lordship. Page 107 of our affidavit.
Yes.
I'm directed to say, this is the government of India. As per request of government of Manipur, it has now been decided to implement the Tipamuk hydro in Manipur, presently been executed by NIPCO as a joint venture among NSPC 69%, SJVNL 28%, and government of Manipur 5%. Then your lordship may see there.
No. You see, they were working till 1999 with you.
Yes.
Till
2009,
2009.
when
So
this
the-
happened.
So
Then
this,
after that, we don't have the knowledge, and thereafter, if their affidavit is seen, NSPC, it says that the promoter agreement was signed between NSPC Limited, SJFPN Limited, and Government of Manipur on 22/10/2011, para 10, page 155. But now my friends is showing some documents, your lordship. I'm not disputing those documents.
not necessary. Not necessary. I'll do one thing. You submit your representation to both.
Lords.
Let them fight it out. Why should I say anything?
Lords.
Anyways, you see, this goes against Umadevi, but as per the recent judgment of Dharam Singh, you may have some case.
Jaggo, etc.
And if these are contractual, there is another one, no? The recent one, there is another one recent.
Bholaram.
Church.
Bholanath.
Bholana.
Bholanath.
So, let them consider, both of them. Consider.
Lords, that no.
No, in 2009, the project was handed over to you. Right? Yes.
But these are, but these also.
No, the fact remains, whatever may be, maybe NFPC may not be there. The fact remains that these people were earlier working in the Brahmaputra board. They came over, the Brahmaputra board was transferred to NEPCO.
Lords.
And therefore, it is with NEPCO. Now, it is for NEPCO to look into it.
Lordship,
To consider the
that modification.
heard Mr. S. Bottaku, the learned counsel appearing on behalf of the petitioner. Mr. Debojit Senapati appears on behalf of NEPCO. What is that? Appears on behalf, union? No union counsel. Okay. None heard Mr. S. Bottaku, the learned counsel appearing on behalf of the review petitioners. None appears for the Union of India. Mr. D. Sonapati appears for respondent numbers 2 to 4. And Mr. A.R. Gogoi appears for respondent number 5. The present application has been filed seeking a modification to the directions so passed by this court dated directions in the order dated in the judgment and order dated 8/8/2023 passed in WPC number 934/2011. It is relevant to take note of that the said writ petition was filed before this court by the petitioner, by the review petitioner seeking a direction upon the respondent authorities, that is NEPCO, to regularize the services of the petitioner in terms with the memorandum of understanding dated 14/7/2007, with retrospective effect, and or not to transfer their services to NHPC, and or to stop all process of transferring the petitioner service to NHPC. To stop. This court, while disposing of the said writ petition, was of the opinion that this court cannot issue a direction upon the respondent authorities to regularize the services of the petitioner. However, in view of a submission being made by the counsel for the petitioners, that the petitioners have been rendering their services since their date of appointment, a legitimate expectation had accrued upon the petitioners for the purpose of their case to be considered for being permanently absorbed, this court disposed of the writ petition, giving liberty to the petitioners to submit a representation before the chairman and managing director of the respondent number 5, that is NHPC Prudential Litigation. And this court further requested the chairman and managing director of the respondent number 5 to take a compassionate view to the representations so submitted and pass appropriate orders as deemed proper in the exigency of the services of the respondent number 5. Paragraph 13 and 14 of the said order being relevant, said judgment and order being relevant, is reproduced hereinunder. Next. The petitioners thereupon submitted a representation before the chairman and managing director of the respondent number 5. The chairman come managing director of the respondent number 5, however, informed the petitioners that the appropriate authority before whom the petitioners should be submitting the representation would be to NEPCO, to the chairman come managing director of NEPCO. As the Brahmaputra board under whom the petitioners were initially rendering their services was transferred to NEPCO. It is under such circumstances the present application has been filed, seeking review to the said directions passed in the judgment and order dated so-and-so in WPC number so-and-so. This court have heard the learned counsels appearing on behalf of the parties and have also perused the materials, the pleadings so filed by the respondents. From the affidavit so filed by the respondent number 2 to 4, it appears that by the communication dated 6/7/2009, the Government of India, Ministry of Power, informed the all concerned, including the chairman and managing director of NHPC Limited and chairman and managing director NEPCO Limited, that the Tipamuk hydroelectric project in Manipur, which was executed by NEPCO, would be executed by the joint venture constituted amongst NHPC, SJVNL, and Government of India, Manipur. It is also very pertinent to mention that though such a communication was issued on 6th of July 2009, but subsequently on 10th of December 2012, the Ministry of Power, Government of India have issued another communication to the various concerned, including the Chairman and Managing Director, NHPC Limited, as well as Chairman and Managing Director, NEPCO Limited, wherein the joint venture, which was constituted of NHPC, SJVNL, and Government of Manipur, was reconstituted by a joint venture of NHPC Limited having 69%, NEPCO having 26%, and Government of Manipur 5%. From the above materials, it is therefore clear that initially the petitioners were engaged by Brahmaputra Board in connection with the Tipamuk project. And thereupon the Tipamuk project was transferred to NEPCO Limited. The Brahmaputra Board no longer exists. And the petitioner thereupon continued to render their duties under NEPCO Limited. For a brief period of 3 years from 2009 to 2012, NEPCO Limited was not involved in the Tipamuk project. But subsequently, from 2012 onwards, the NEPCO Limited continued to remain a part of the joint venture with HSPC Limited and Government of Manipur. Under such circumstances, it is the opinion of this court that the directions so passed by this court at paragraph number 13 and 14 of the judgment and order dated so and so in WPC number so and so is required to be modified, taking into account that the petitioners, taking into account that this court, while passing the said order, the judgment and order did not take in, was not taking into account that attention was not drawn to this court at the time of passing the judgment and order dated so and so. That NEPCO Limited still continues to have a stake in the Tipamuk project. And this court passed the said order on an assumption, on the basis of submissions that the entire Tipamuk project was taken over by NHPC Limited alone. Under such circumstances, this court therefore modifies the directions passed in paragraph number 13 and 14 of the judgment and order dated so and so, thereby granting liberty to the petitioners to submit a representation before the chairman and managing director of the respondent number 2 to the respondent number 3 in the writ petition. The chairman, it's the managing director, na?
Chairman.
To the chairman and managing director of the respondent number 2 in the writ petition. And this court further requests the chairman cum managing director of the respondent number 2 to take a compassionate view of the representations it so submitted and pass appropriate directions, orders as deemed fit in the exigency of the services of the respondent number 2. Mr. S. Bottakur, the learned counsel appearing on behalf of the review petitioner, submitted that the said representation would be submitted within 30 days. It is observed that if such representation is being submitted to the respondent chairman cum managing director of the respondent number 2 within 30 days from today, along with a certified copy of the present order, the chairman cum managing director of the respondent number 2 shall do the needful within a period of 6 months therefrom. 6 months. In doing so, the chairman and managing director of the LEPCO of respondent number 2 shall also keep in mind the directions passed by the recent directions passed by the Supreme Court in the case of
Bholanath.
these were contractual of Bholanath so and so
Versus State of Jharkhand and others.
versus
State of Jharkhand and others.
reported in
Lordship, I don't have these.
I
I don't
silo.
report. This is,
SCC online not silo.
I will find out.
A copy of the state judgment be also submitted along with the representation for due consideration.
Only one fact that Tipamuk project has been basically found unviable. since the year 2013, and that project is no longer there. So just bringing the Tipamuk project is no longer there.
Where are they working?
They are to real, Your Lordship.
That now
Well,
they
I
say
have
it's
handed
Turiel.
over this.
We'll put it at Turiel.
Lordship.
We do one thing. You do one thing. Ito order to thako alage. Mr. S. Botaku, the learned counsel appearing on behalf of the petitioner, submits that the petitioners have been rendering service, were rendering service at the Tipamuk project till 2009,
Lordship.
19.
Lordship.
9.
9, Your Lordship, initially.
9, it can't be.
No, Your Lordship.
9, the project was taken
Over.
Taken
But
over.
in the meantime, Your Lordship, we were brought to real, Your Lordship, during pendency of the writ petition. That exact date.
That statement has not been made.
No. That is the problem. That was
Mr. S. Botaku, the learned counsel appearing on behalf of the petitioner, had submitted during the course of the hearing that though the Tipamuk project was handed over from NEPCO to the joint venture of NHPC Limited, SBJNL, and Government of Manipur. But and at the same time, upon handing over the same by the Ministry of Power of the Government of India, the services of the petitioners were transferred to the Turiel project
hydroelectric project.
in the state of Mizoram, which is under NEPCO.
Lordship.
This very aspect of the matter is, however, not apparent from the review petition. And it is of the, and it is, this court is of the opinion that the said that if the petitioner wants to seek a review to the order, judgment on order passed dated so and so in WPC number so and so, this aspect has to be brought on record by filing an additional affidavit. List this matter on 31st of March 2026. In the meantime, liberty given to the petitioner to file an affidavit. You are already out, that means.
No, deeply.
Your entire review is misconceived.
Because, Your Lordship, the problem is that neither they provide us, first of all, Your Lordship, since 2010, long back, no connection. Then came, Your Lordship, with certain.
But you should have, your basic, you should have
Lordship.
told that you are into real.
It is only, Your Lordship, last few days back, Your Lordship, I am handed over a bunch of documents, Your Lordship, which says, from which I found that they were being transferred. They cannot even say that when they have been transferred. That's the problem.
And how many years of service left?
For some, Your Lordship, 1 year probably, 2 years, 1 year, 2 years, like that.
You should have brought up your case properly as per that, na?
Lost.
What is this?
You see the fellow say, notice of eviction, my lord. Yes, what happened, my lord? The garden land has been ordered to be Sakai land by a settler officer without income. 93 bigha note. If you also see, my lord, the annexure 1.
Why?
My lord,
Why government land has been becoming a...
no, nothing, my lord, no explanation. If you
Huh?
also see at page 18, that note is there. And government of Assam also asked why it has been done. They could not reply.
During
So-
1970, while resettlement operation was on, the land measuring
92 bigas were declared as sorry.
How?
Yes, my lord. The matter has again been re-examined in the year 1975. Height, my lord, this sealing case number 1/75. So in that way, this is sealing surplus land, my lord. And since then, petitioner has been paying Tozibahi revenue to the government. 2015, when notice was issued for demarcation of land, my lord, at that stage, he came before the petitioners came before this honorable court, challenging the notice of demarcation for demarcation. And apart from 92 bigas of land, another 10 bigas, my lord, this is absolutely for government land, my lord, that has also been total 102 bigas. And my lord, thereafter, the petitioner has submitted a representation that has been referred to the Revenue Department long back, 1990, my lord, and petitioner himself has annexed, my lord, annexure Roman 2, my lord. It has reflected the stand of the respondents. And may I please communication number. Studies need to understand the case of the respondent.
Well, this is covered by tea plantation. Well, there is no question of sealing surplus matter. Covered by tea plantation. Government's data is there, my lord, which will also see at page 21, my lord. Yes,
One quarter.
Mr. Goswami,
page 21, the government has also asked, my lord. Page 21, answer 3.
see, a land which is vested upon them can be unvested only by operation of law.
Why, madam?
Operation of law.
Yes, sir.
The operation of law in respect to a sealing case would be the final statement under section 7(6) of the 1956 Act. Show me that.
That is my respectful submission as has been reflected at annexure 2 of the Roman 2 of the my lord affidavit, my lord, that has been reflected, my lord. And the entire matter has, since there is no provision to reallocate the land to be in favor of the petitioner, the then deputy commissioner, my lord, forwarded.
Where is annexure 2 to the affidavit? There is no affidavit annexure 2.
This is annexure Roman 2 of the writ petition.
Of?
The writ petition.
Yes. This letter, I've seen it.
Yes.
I've seen this letter, but that is not the question. My question is, no, Mr. Goswami. Mr. Goswami, I make it very clear. Unless you show me that there is a final settlement made under 7(6), final statement published, because even at the state of 7(5) also, it cannot happen. That statement has to be published. Then only the sealing case takes over. Till if it is not there, no records are available, gone.
Mother, lordship, it can be considered. It was taken place during 1970.
Mr. Goswami, all sealing
Yes,
cases of tea gardens are 75, 76 only. It started from 1957. What happened to that case? I delivered one judgment long. What happened to that? Where I did, Mr. Deka was there. It's a huge plot of land. Huh? There are a lot of people who are in possession of that and all these things. But the fact remains, unless you have the 7-6 statement, you can't do anything. And that is the most.
Before lordship by the petitioner.
No, we
All
don't
along,
know at all.
all along, my lord, on behalf of
Copy has
the
been
petitioners, my lord, submission has been made that illegally, without
Yes.
notice,
Yes, yes,
my
we
lord,
have said.
without notice, my lord, the land has been taken over by the government. In fact, the land, entire land in their possession, my lord, the facts remains that, my lord, the initiation was taken place during 70, then 75. It was it was
No.
sent-
The time which you are saying, Mr. Goswami, is exactly the appropriate time when the 70-75 was the time.
Yes,
When
and
all tea gardens, all these the proceedings were done in the 56. But the question is,
whether
if you
that
don't
is-
have records,
my lord,
can't help it.
that is the last paragraph, lordship will see, along with his representation, my lord, along with his representation,
What?
everything was submitted to the government. Base 20, lordship will kindly have a look at.
Under such circumstances, the prayer of the petitioner to Allah or Iman is forwarded to you for favor of your kind consideration and so and so. Then
Yes.
this happened in 1990.
Action as a special case, since the present law further no settlement for cultivation is admissible. The petition in original along with all relevant papers also forwarded here.
No,
Possibly, my lord,
but
perhaps-
Mr. Goswami, why you are going into the question of further allotment or settlement?
No.
A
Since
land
yes,
which is settled cannot be divested unless it is done under Section 5.
Section 7, yes. Perhaps, my lord, perhaps all the records will forwarded to the government, to the revenue department, my lord. That has been reflected in the annex at that time, saying.
If you don't produce it, this court has no other option but to set aside. Mr. Barbudari,
That part, my lord, I think.
I hope you understand.
They have admitted that in 70, how the settlement officer is done.
Well,
No, maybe, but if there is a 77-6 notification, then it's a different aspect of the matter. Otherwise, matter is over. We have to show this land. It's not a question of allotment, reallotment or anything. It's a case that we have to change the Sarkari to that. It's very easy. What happened? Is there 7-6? Ask the deputy, the DC at that point of time who is there. Where about the review filed and all? This is not this document does not show to be a review. A review normally is also permissible before the minister. But we are not on that. Let us go into the question of find out as to whether in Gopal Krishna Kiste, whether any sealing proceedings were initiated. I think 100% it must have been done.
Yes.
Mr. Borpade, 100% it will be done because all these states, because in 1970-71, it started sometime around 1967, all gardens, where the government started taking away those areas which are beyond, not
Yes.
permissible under Section 5,
Right.
Rule 5. Only way is sealing. And sealing will apply if Section 5 is there.
Sealing will apply whether in pursuance of any sealing proceedings or otherwise, how the land has become government land. This is to be found out at this moment. Now, the instructions that I have placed before my lord, which lordship sees, and the affidavit also, one of the affidavits, but if lordship allows me, my lord, I will just read the affidavit. Affidavit, my lord, filed by the district authorities, yes. My lord, yes. The deputy commissioner.
that affidavit, my lord, uh, deponent is one Ananta Kumar Gogoi. There, my lord, at paragraph 5, if I may read it, my lord. As per report from the circle officer, Mayong Revenue Circle, a letter was issued to the authority of Gopal Krishna Tea Estate by so-and-so dated 15/12/2015, informing that the following schedule of government land under Puthari Bagisa Kisam would be demarcated on so-and-so and encroachment to be cleared on 23/12/2015. As per the up-to-date land records, these are government land and land areas under dark number so-and-so have been enclosed by Gopal Krishna Tea Estate. Then it goes on to say, my lord, at paragraph 6, my lord, as per report from the circle officer, Mayong Revenue Circle, a proposal was received from the authority of Gopal Krishna Tea Estate by letter number NIL dated 2/12/2015, wherein the Tea Garden Authority offered alternative tea estate land in place of government land, as the encroached government land is in the midst of the garden, most of which is under tea plantation. But on examination of the proposal, it is found that the area under DAG number 153 of special periodic patta number 1 of Uthari Bagisa Kisam, which was proposed for exchange with government land, DAG number so-and-so, is neither suitable for cultivable purpose nor fit for residential purpose. The circle officer Mayong also issued a letter to the authority of Gopal Krishna Tea Estate by letter dated 24/12/2015 to submit relevant documents in favor of their claim that 93 bighas 2 kotha 8 lesa of land of Kuthori Bagisa Kisam was declared as Sarkari unilaterally by the settlement officer Nagaon in 1970. But the authority of Gopal Krishna Tea Estate had failed to submit any documents to substantiate their claim. Then, my lord, it goes on to say that as per the latest policy of the government of Assam, 14 bighas of government vacant land under DAG number 158 of Puthari Bagisa Kisam was distributed among 56 landless tea garden workers on 24 January 2016. Under the program dated 24 January 2016, each tea garden landless family received 1 kotha 5 lesa of government land, and allotment certificates to 56 landless tea garden workers were issued accordingly. Then, my lord, a notice, as per government records, most of the land as shown in the above paragraph is being enclosed by the authority of Gopal Krishna Tea Estate, and therefore a notice was issued to the authority of Gopal Krishna Tea Estate for eviction on dated 15/12/2015. Now, this affidavit says, my lord, that they were encroaching upon government lands, and those part and parcels of land were made Sarkari land way back in the year 1970. And the fact that those part and parcels of land were, my lord, illegally or otherwise made Sarkari, to that extent, my lord, they have not been able to substantiate their claim. This is, my lord, the sum and substance of the affidavit. So it is
Understood.
not
Kindly come to page 18A.
18A, my lord, of the writ petition. Only, my lord, 18A is not available.
Okay, come to farm 19.
19, yes, my lord, I have another request. Another.
This is a letter written by the Deputy
Yes,
Commissioner.
18A, I got it, my lord.
Paragraph 1.
Para 1. Allotment settlement of 93 bigha 2 kotha showing Gopal.
Paragraph 1. The settlement officer Nagaon.
Yes, settlement officer Nagaon by this order number so-and-so 70 declared an area of 93 bighas 2 kotha 8 lesa of land as Sarkari from Kuthori Garden under NLR grant number so-and-so during last resettlement operation. The
So
details,
therefore,
yes,
it is only in 1970 this was declared to be Sarkari.
yes,
This is what the Deputy Commissioner says. So therefore, the most important question is, once it is being said to be Sarkari, under why? How? Why?
Answer is at paragraph 2.
Ah.
The land ceiling case number 1 of 73 under the Assam fixation of land on relating to Gopal has also been examined. It is seen from the return under form A1 by the garden authorities that land exempted under section 4.2 of the act as ancillary to the tea cultivation has already been kept by the garden. It is also found that the total area under tea cultivation of the garden was at the relevant time 2,249 bighas, 4 kathas, 8 lesses, and admissible under section 5A of the act has already been given to the garden. That is 674 bigha, 4
So
kathas.
therefore, the question is, as I am saying, this land was found in excess of the permissible land which can be withheld. Means the land under tea cultivation or anything ancillary thereto. Because once it comes under tea cultivation or ancillary thereto, then it is outside the scope of the Land Ceiling Act. So therefore, at this point of time, there must be something.
At
Now,
that point of time.
yes, and for that you need a 7.6.
Yes.
Where is that? That is what I have been asking.
Yes. No, if it
My
is done
simple
under-
question is this.
No, sir. If it is done under the provisions of lands, why not that 1956 Act, the record has to be. We have to be
That
WCO.
will show everything.
Yes.
The final statement. Thereafter, they have case or not case, you want to evict them, very good. But that you have to show me.
Because to that extent, all the affidavits are silent. Therefore, my lord, it was my duty to point it out before this.
No, therefore, my question is when Mr. Goswami opened his mouth, also, my only first thing is 7.6.
Yes.
Because this is how it is.
My lord,
Once 7.6 is shown out there, matter is over. You go and evict them people. Because because if 7.6 is not there, the entire thing is bad. So therefore, settlement operation doesn't question, no arises.
The government has asked that, page 21, if you will see. Government has asked the deputy commissioner, with reference to above, I am directed to say that it seems the case of restoration so-and-so land was purchased in 1960 and has been in continuous possession and under actual T. The circumstances under which the idea was made Sarkari are not adequately explained by in your report. However, the government authority can only be directed to police. Then, my lord, the report is at page 22. They say that no reason, my lord. It's better one. On the above subject, I verified that the copy of the Sita and so belonging to the Gopal Minister was made Sarkari by the then settlement of
Yes.
the site, but no reason so to appear to have been recorded as per copy of the.
This is also precisely what has been stated in the instructions which Lordship has just now perused. These instructions we have received in the year 2023. Now it also speaks of the same minor factual position.
No. What these people are trying to find out is that order of 6309/70. You see page 23 of the writ petition.
No, yes,
Informed that a settlement order number so and so by the settlement is not traceable in our records.
yes, not in our.
Okay, I'm not on that. But you would be having that sealing proceedings.
Therefore, kindly see my predicament. This instruction also says, my lord, if I may read it, the land so and so number Gopal Krishna Tea Limited name was striked off and it was written as government land, though no order was found in the remark column of the Chitra. So but I assume for the time being that all the minor provisions of the 1956 Act have been complied with, and their land have been taken, and it has been made Sarkari land. It attains the character of Sarkari land. Assuming. Then also in the Chitra, there has to be a remarks column. How it came to be incorporated in the Chitra. If that is not there.
It would no longer be a part of the grant.
Yes.
The moment it becomes a government, it's no longer part of the grant.
Yes.
But the very letter which is I'm reading at page 20
Yes.
also clearly shows that it was a part of the grant.
It was a part of the grant.
So unless there is a the draft or the final settlement which is being done under 7C, not there, petitioner has a case. That is the problem. When do you want it?
Whether sealing proceeding had in fact taken place at
These
that.
instructions are here only. The one which you showed it to me, I think it was shown on 26/9/2025.
Perhaps, my lord, an affidavit has to be filed by the district commissioner. Affidavit has to be filed.
Affidavit won't do. The
No.
question is, only thing is you have to, because it is a grant land. Grant land, if it is goes out, it can only go out by the 56 Act.
Therefore, whether, my lord, any sealing proceeding was at all initiated for divulging that plot of land from the tea garden and, my lord, incorporating it to the Sarkari land, whether any sealing proceeding had taken place or not. To that extent, my lord.
It appears so. It appears so.
Appears so, but.
Because of at page 21 of the
Yes, it
reputation.
appears so.
But my lord, page 54, Jamabandi, it says, my lord, that thing. Page 54, you can also see. Jamabandi.
Prohibition of article.
Right, right.
Like,
Yeah.
Right-hand column, my lord, the second one. As per order during number so and so, part by so and so, my lord, statement, sir. That is so and so in Chitha, number so and so. And your new lease grant, accept the plot of land measuring 86, the rest of the land falling under the tag number so and so, so and so. Measuring so and so has been converted to government.
No, it's okay. No, this, they have done it.
In 70, it was done. 70, my lord, at the time, no ceiling posting was there. At the, annex the photography of the original also.
Is this tea garden functioning?
Yes, my lord, tea garden functioning and this is covered by tea garden, tea, my lord, tea bushes. Only one tag is there. My lord,
Mr. Goswami, have you seen any tea from Gopal Krishna?
yes.
At one point of time, we used to see there's some tea. Nowadays, we don't see any tea garden out there.
No, they actually, my lord,
Maybe because of the
There's a
roads, the 4 lanes and
photos,
all, huh?
the land perhaps falls in that Nelly area. Therefore, my lord, that exchange with Nelly.
No. This is before Jagirod. Gopal Krishna will be just before Jagirod, if I'm not wrong, or just after.
Mayong.
Yes. So therefore, it will be before Jagirod.
Yes.
I remember it. Like, before Jagirod on the right hand side.
Yes,
If you are going from here. Ah, yes. No. Before Sikhaga. Sikhaga is beyond Jagirod. This is prior to that. Just before reaching this. This is a very valuable land. Ah, on the right hand side. It's a very valuable land now. On the right hand side, it is just abutting the main road. And this area, that is what the map shows, which the moment I saw this map at page 58. This is the road by which you go. See,
Yes.
this is the road which comes. See that on the right hand side? When do you want it?
Earlier it was within the district of Nora.
Now it is Morigaon.
Yes, now Morigaon. Earlier it was Nora. That is why the problem was. But in any case,
Unless you find out that there is no way out, we have to set aside this. Unless it is not there, we have to set.
Absolutely. Because
I'll
the
give you a
instruction
chance.
says-
I'll give you a chance. How much time do you require? This is the old matter. And also argue on, this is a writ petition filed in the year 2016. Also argue on the point that they have, the land, they have allowed it to remain as Sarkari from 1970.
Yes.
Argue that point also.
We have been paying this.
Cozy.
So the-
Argue on that point also. Can it,
Paying to
can it be sustainable? It's a different thing whether I will permit or not. That's my question. But argue that because you see, recently there are judgments out there. So if you are not claiming this land, you have allowed it to be a government for such a long period, then can you raise it? I saw some judgment
Yes,
recently.
it is there. One from Himachal Pradesh is also there.
No, Himachal Pradesh is the other one. That is the Vimla. That is different. Where?
There is another, my lord.
Ah,
In 78, we have
Striking
touched
me
them.
right now, my lord.
In 78, when it came to know, my lord, we raised the point.
you raised the point, but what were you? Why were you sleeping till 2016?
My lord, because correspondence are going on.
No correspondence. 1990, the last correspondence.
Yes, 1991.
And then, what are you doing? We are moving after 26 years. And we are going to decide after 36. 20, 30, 30, 56 years.
Now,
Ah. The order is older than me. So how can I decide?
Hello?
The order is older than me.
if Lordship could please to take this on next week, my lord.
Next week? No, next week. You see, I will give you a genuine chance to come up. If you have any records. That is,
We will try.
don't take it that this court is going to. I have asked you to take on the ground of laches. That is another aspect. But that doesn't mean that I am going to dismiss his petition on that. There is another point which you may urge, taking into account that 56 years the order has remained.
It's absolutely correct, but not my predicament is that.
Or do you think that a judge who was born by or had attained the age of 56 or 57, he may say that, okay, I was born when the order was passed and therefore the order can be set aside?
Absolutely not.
Then,
The difficulty is that, my lord, how come this land it has been characterized as government land? To that extent, no record is available in the specific instruction. Nonetheless, this communication available.
no. What instructions appears out here is something different. What they are insisting on.
Yeah.
They are insisting on why the settlement order officer.
Taking it other way around. Yes.
Don't go into the settlement. Just find out the sealing case. Once you file the sealing case, the matter will be over.
Lordship may be pleased to make some observation. It will give me a handle
Yes,
to persuade the authorities. Some observation. It will give me a
Heard
handle to
Mr. J.N.
persuade the authorities.
Sahavala, the learned counsel, appearing on behalf of the senior counsel, assisted by Ms. S. Todi, appearing on behalf of the petitioners, Mr. Arbor Pudari, Mr. B. Usami, the learned additional advocate general, appears on behalf of the respondents. The respondents state, and Mr. Arbor Pudari appears on behalf of the Revenue Department. The issue involved in the present petition is as to whether is pertaining to a plot of land at measuring 103 bighas, 2 kathas, 13 land. 13
19
acres.
bighas, my lord. 10 bighas, my lord, my lord, that I am giving.
Huh?
10 bighas, there is no.
So what
Is Mr. Counsel. Let me go as per the petition. 103 bighas, 2 kathas, 13 lechas of Moza Gova of village Kuthuri Bagicha, falling under DAG number 190, 187, 186, 168, 161, 158, and 264. Whereby the said land was made Sarkari on the basis of an order passed by the settlement officer dated 1911-1970. It is pertinent to take note of that from the materials on record, it appears that this plot of land was a part of NLR grant number 102/36. And this NLR grant was held by the petitioner company. There is no doubt that the provisions of Assam Fixation of Land Holdings Act 1956 provides power to the state some fixation of ceiling on Land Holdings Act 1956 empowers the state to impose limits on the amount of land that may be held by a person. But the said Act of 1956 is not applicable to lands held and utilized for special cultivation of tea and purposes ancillary thereto. It is also pertinent to take note of that Section 7 of the Act of 1956 provides the manner in which the land shall vest upon the state in respect to vest upon the state. The final statement, which is required under Section 7(5) of the Act of 1956, is the document by which the land vests upon the state. This court further takes note of Annexure 2 to the writ petition, wherein there's a reference to a land ceiling case number 1/75. 75 or 76? 75. 73 or 75?
No, my lord, it will be 73.
73. 1/73. Which appears that there was some proceedings initiated under the Act of 1956. Be that as it may, if some land ceiling case number 1/1973 was initiated, in the year 1973, it could not have. The settlement order, the order passed by the settlement officer on 19/11/1970 prima facie appears not, prima facie appears to be. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . not in consonance with law. Accordingly, also, this court directs both the state as well as the respondent as well as the revenue department to place materials on the basis of which the land in question stood vested upon the state. List this matter on 31st, 31-3,
Can it be some days prior?
Tuesday.
If
Or are you going to say that elections are there? Interim order is there, na?
we have one at 27th or 26th. 26th. 26th.
On 26/3/2026. Interim orders passed earlier shall continue till the disposal of the petition. 70?
Because
the Ceiling Act was amended, Mallory 72, then only it made applicable.
in the
No, if that be so, then how can you have an order passed in 70? E-settlement operation also you cannot.
settlement operation, it is a fallout.
Fallout,
It
it's
is
a
a
different thing. But if you are saying about the Land Ceiling Act, if it has come in 73 or 75, so therefore 70 order cannot be sustained.
It cannot proceed.
Anyway, hello.
Point to line.
In this writ petition, Lordship, I challenged the office memorandum issued by the Finance Department, wherein Lordship, the cost of repair has been outsourced. And which is, Lordship, that office memorandum is dated 30.
And the other petition is for what? For regularization.
For regularization on Lordship, for the scale of pay attached to the post, Lordship, I should.
Okay, so there in that case you are working.
Yes.
You're getting. We do one thing, we issue notice here. This aspect is a very important aspect as to whether the circular of the finance department can override the, have you made the finance department a party? Where's the finance department? Oh, yeah, he is. Issue notice making it returnable on April 9th April 2026. That's the HK Das accepts notice on behalf of respondent number 1, 3, and 4. Mr. Arbu Pujari accepts notice on behalf of respondent number 5. And Mr. J. Hendik accepts notice on behalf of respondent number 2. Extra copies of the writ petition be furnished to the learned counsels by tomorrow. The petitioner herein, who is presently working in the office of the office of what?
Court of SGM Gosaigaon under the establishment of Lordship CGM Procedure.
Office of the respondent number 4. In the capacity as a sweeper, na? is aggrieved. Part-time sweeper is aggrieved by the notification dated
30 March 2012, page 70.
30 March 2012. Didn't it?
Yes.
Whereby? Sweeping and cleaning services are to be outsourced, and the post of sweeper shall not be filled up in any department on any ground, including compassionate grounds, except in government hospitals. The learned counsel appearing on behalf of the petitioner submitted that the said office memorandum dated 30/3/2012 though have been challenged on the ground of has been challenged on the ground of Article 14 and 16, a violation of Article 14 and 16 of the Constitution. It is the further case of the petitioner that the petitioner is also entitled to be regularized in any grade 4 post in the court of the SDJ. And also till such decision is being taken, the petitioner should be paid the minimum of the scale of pay as is given to other grade 4 employees in the same establishment. The respondents herein shall bring on record their stand by filing the affidavit on or before 6th of April 2026. List this matter along with
5747 of 2000.
on 9/4/2000. What is there? Has the petitioners filed any FIR?
Lordship, they have stated, Lordship, at para 11 of the.
No, that they have stated somebody else filed it, but why the petitioners didn't actually, they can file a writ petition out here, but they cannot file an FIR. And when did this happen? In 2015?
Yes. He's claiming some reimbursement.
Let's see the discharge certificate. What does it say? What is the discharge certificate say?
After discharging from.
Neonatal death. After that also, if they don't file an FIR, but they can very well come to the High Court. None has appeared on behalf of the petitioner on call. Mr. D. Upamanyu appears on behalf of the respondents.
One.
Respondent number
One.
1, 2, 2 and 3. DC D. Hendrik. 5. 5 also.
BTC.
Not BTC, medical officer also. Medical is not the transfer subject. No. Not medical.
And Lordship, someone else is appearing, Lordship. In the cost list, someone.
Okay, you appear for 5 and 6. Anyways. The petitioner herein has approached this court, have seeking various directions. On allegations that the child of the petitioner was taken away by one Thaneswar Doimari from Baksar district. And the petitioner thereupon was issued a discharge certificate on 7/6/2015 stating inter alia that the child had expired. Under such circumstances, the petitioner have sought for various inquiries and for compensation. The records reveal that the petitioner never filed any FIR as regards the said incident and directly approached this court by filing the present writ petition. An affidavit in opposition has been filed with respondent number 2. Wherein it is being mentioned that an inquiry was conducted and it was found that the petitioner's wife received 2 ANCs in total during her antenatal period, and she delivered before term, that is at 28 weeks of gestation. What is LMP?
Last month,
What?
last mensuration period, Lordship, last mensuration.
Last mensuration period, LMP. Date was 22/6/2013, and the date of delivery was 7/1/2015. 14. What is this? I don't understand. How does it make any sense? Yes, who appears for response number 2? How does it make sense? The petitioner was discharged on 7/6/2015. Itu agak kini usai. Had filed an affidavit on and respondent number 2 had filed an affidavit wherein it was mentioned that the petitioner's wife was admitted on 3/6/2015 with labor pain, with breech presentation, with and polyhydramnios, with absence of fetal movement. What is your stand? Did you conduct any inquiry or not? This court duly takes note. Affidavit of authority. This court duly takes note of that by an order dated 7/6/2024. This court directed the petitioner to bring on record the FIR and also orders passed by the jurisdictional magistrate as highlighted in paragraph number 11 of the petition. It is seen that whenever the instant repetition has was the baby recovered,
Yes, sir. Yes, sir.
and why the discharge certificate is the what have you done is regarding the discharge certificate? Is there any what does the discharge certificate say? D2PO, what do you mean by this? Annexure 6, page 40. Nigel, none has appeared on behalf of the petitioner on call. Mr. Yati Kunigudi appears. The present petition has been filed by the petitioner. Seeking various directions as well as compensation from the respondent authority as well as for compensation for proper and adequate for compensation for mental and physical trauma. It is a case of the petitioner that his wife gave birth to a child and thereupon the child was taken away by some person. It is also mentioned that the petitioner thereupon could retrieve the child with the intervention of the All Assam Borough Students Union and the intervention of the jurisdictional magistrate. The trauma which was felt by the petitioner's wife, as well as by the petitioner, have constrained the petitioner to approach this court by filing the writ petition. This court duly takes note of that by an order dated 7/6/2024, a direction was issued to the council for the petitioner to produce the FIR as well as all the orders passed by the jurisdictional magistrate as highlighted in paragraph number 11 of the writ petition. Various opportunities have been granted to the petitioner to produce the same. But the petitioner have failed to produce. Taking into account the above, it is the opinion of this court that the petitioner herein is not interested with pursue with the instant proceedings. And accordingly, this court therefore dismisses the instant writ petition for non-prosecution. Yes. Anybody, any interim order, any urgency?
Lordship may kindly fix a date for item 4.
What is that?
Item number 4, my lord. I will be traveling from phase 4 for this matter.
Hmm?
Kindly fix it. Item 4, my lord.
4.
4.
What is that?
Any date, my lord, convenient to this court.
And these matters, Mr. Das, where is that? These are all pertaining to those matters, na? Rule matters, na? Rule, I think, this 8/6 to 11, let's have it after Bihu. Yes. Item number 6 to 11, taking into account that there has been Mr. H.K. Das, the counsel appearing on behalf of the Gauhati High Court, submitted that the Gauhati High Court on the administrative side is taking appropriate steps for finalization of the rules. And in fact, to his information, the same have been sent to the legislative department of the government of Assam for doing the needful. Taking into account the above, list this matter again on 23rd of April 2026. And what else? Other matters, you kindly take your dates.
Item number 30, my lord, we filed the amended counterclaim as directed.
What is this? 30.
Lord, yes, my lords had directed us to file the amended counterclaim by the end of the day. We filed it.
Oh, you have filed it?
Yes,
Who is for the respondent? Who is, you are respondent number 2 and 3?
3 and 4.
Okay. Who? Okay.
May
The
please, Your
respondent numbers 2, 3, and 4 have filed their counterclaim, have amended counterclaims.
My lord, the counterclaim has only been filed by defendant number 2 and 3.
2
Defendant,
and 3 have filed their there are 2 counterclaims. No?
yes,
The respondent number 2 and 3 have filed their respective counterclaims, amended counterclaims, pursuant to the order passed by this court dated so and so. About it. Mukherjee, Mr. B.J. Mukherjee.
May please, Your Worship.
the petition
Item number 29.
Wait,
and for the.
Mr. So and so, who appears on behalf of the plaintiff, submits that they would like to file the written statement. List this matter again on 6, no? 5, no? On 6th of April 2026, the written statement be filed on or before the next date with advance copy to the others.
May please, Your Worship. Item number 29.
What is that?
I have got the relief.
Oh, yes.
My bank account has been unfreezed.
Bank open, huh? But Mr.
A. Malik,
A. Malik, the learned counsel appearing on behalf of the petitioner, Mr. N. Bolwa appears on behalf of the SBI. Mr. H. A. Malik submits that the bank account have been defreezed and accordingly the petitioner would not like to further press the petition. Taking into account the above, the instant petition therefore stands closed. What about that? There is another matter.
28, my lord.
27.
28, my lord.
28 also.
And personal, my lord.
Same.
Same.
Okay, same order. And who appears for you for SBI, na? H. Pura Gohai and Mr. Swens. It is a close call. I got instructions.
Item 32, my lord. So
32?
next week. That's CRPF matter.
What happened to this matter? Anything? Eh. What do you want to do now?
My lord, my lord, we have received the letter from WhatsApp yesterday only, my lord. So, my lord, can it fix the matters in next week, my lord, so that we can take instructions.
As per the request made by the respondents, CRPF,
CRPF.
the concerned circle officer, the circle officer, which circle?
Sonapur.
Unapur Revenue Circle have carried out the demarcation and indicated the area to the respondent CRPF. Copy of the said demarcation. Notice the minutes of the report have also been furnished. You've got it?
No, WhatsApp, not officially, my lord. That may be mentioned, my lord. Not officially.
Copy of the year. Copy of the said demarcation notice or proceedings have been furnished, have been placed before this court on the basis of an instruction dated 2/3/2026, which is kept on record and marked with the letter. A copy of the said instructions dated 2/3/2026 along with the enclosures have also been furnished to Mr. A. Das, the learned counsel appearing on behalf of the petitioner, and Ms. A. Gayon, who appears on behalf of the respondent.
I have not been furnished. Mr.
I also know. What is this? Do you suspect Mr. Burbaya would not give you? She also have not got it.
Yes.
Furnished to so and so. Respondent CRPF. By Mr. J. Hendrick, the learned counsel appearing on behalf of the respondent state. Miss Agayon submits that she would obtain necessary instructions in the matter. Accordingly, lists this matter on 12th of March 2026 at 10:30 AM. সেইটো ভৰাই দিব দেই, XYZ হয় ABC. You give a copy to him as a proof.
Your lordship, my lord, item 31, my lord.
Ah.
Item 31, my lord. Contempt matter, my lord. Non-issuance of the land sale permission, my lord.
Non?
Land sale permission, my lord. Non-compliance with the order, my lord. Contempt. Other side is filing affidavit, my lord. It is on come on record, my lord. And it may come on record and maybe.
Lordship, we have filed an affidavit yesterday, as per the order dated 24/2/2026, but this support.
May come up on next week, my lord.
Okay, we have it tomorrow at 2. You want to? No,
My lord. I have,
you have no urgency.
urgent is there, my lord, of course, my lord. But I have to file a reply, my lord, that's why.
You want to file a reply?
Yes, next week, so.
Okay, an affidavit in opposition has been filed by the respondent number 2. So Mr. A.K. Talukdar, appearing on behalf of the petitioner, submits that the petitioner would like to file a reply. List this matter again on 30th of March 2026. In the meantime, reply be filed on behalf of the petitioner by the petitioner on or before 27th of March 2026. Why you are filing contempt reply? It may be an order must have been passed rejecting. It has to be challenged. You are filing, you are only delaying it. Yes.
May please, your lordship. I beg item number 18, my lord. And a very old matter, my lord.
How old?
1818. 15 matter.
15 matter.
Wait, my lord.
14 and 15 connected, na? Why it has come up for orders?
Lordship, 18.
Huh?
18, my lord.
18.
The 14 and 15 is also why the matters have come up, Sailubusu. The order to go. You are on 18, na?
18, my lord.
What is this?
Land compensation, my lord.
Till next week, next Tuesday at 2 PM.